Welcome, tribal leaders, colleagues, and friends to our webinar, Engaging the USPTO on Our Terms, Advancing Indigenous Interest in Genetic Resources. My name is Trevor Reed, and I'm excited to be here with you. Trevor Reed ban Yan Pahan Matsiwa. My name is Trevor Reed, and I'm a member of the Hopi tribe and a professor of law at Arizona State University. Co-hosting with me this morning is Makalika Naholova'a, who is the executive director of the Native Hawaiian Legal Corporation and president of the National Native American Bar Association. Welcome, Makalika. I'm joined today by tribal leaders, legal practitioners, and scholars who've been working at the intersection of intellectual property and Indigenous rights for some time. The goal of today's event really is to unpack these recent requests for consultation and comment that the U.S. Patent and Trademark Office has recently issued. These invitations for comment and consultation have the aim to gather information from tribal nations about their views on genetic resources and traditional knowledge and traditional cultural expressions and other topics relating to intellectual property. And this information will purportedly assist the Patent and Trademark Office as it negotiates a handful of international agreements that are being developed by the World Intellectual Property Organization, or WIPO. So we're here to help sort out what these requests mean for tribal nations and also to help brainstorm strategies for responding to them. So before we dive in, I would like to first thank all of the sponsors that have been working to put this webinar together. I want to thank, of course, the National Native American Bar Association, the National Congress of the American Indians, the American Indian Law Program at the University of Colorado, the Implementation Project, the Native American Rights Fund, and UCLA's Native Nations Law and Policy Center. They've all been working together to put this together, and I want to give them a big thanks for all of their support. Before we go much further, as part of this webinar, we're going to welcome your participation as audience members. A lot of times webinars are just kind of, sit back and watch, but we actually want to encourage everybody's participation today. You can do that in two ways. First, you're welcome to type in a question or a comment by clicking on this Q&A button that's down at the bottom of your screen, and you can enter your question there by typing it in. But also during this webinar, we'll have brainstorming sessions. We'll have two of them, one at 11 a.m. Mountain Time, and then another one in the afternoon at 2:30. And during these brainstorming sessions, you can actually voice your opinions, your thoughts, the strategies that you have, or other ideas that you might have by clicking on the raise hand feature. And then one of the moderators will actually invite you to speak, so you'll be able to use your microphone and speak to the audience. Just to give you a sense for what we're going to be covering today, we'll start with a quick discussion of some basic vocabulary. What is the U.S. Patent and Trademark Office? What's intellectual property? And what do we mean when we say things like traditional knowledge or traditional cultural expressions or genetic resources? At 9:15, we'll learn about the World Intellectual Property Organization and the negotiations that are currently happening there at WIPO. And we'll also get a tribal perspective on what this effort all means. And then at 10 a.m., we'll have a roundtable that's aimed at understanding the Patent and Trademark Office's request for comment and consultation, including how the USPTO, what obligations it has to tribal nations under federal law and also under international law. And then we'll start discussing how tribal nations might use this understanding as they're responding to the USPTO's Federal Register notice. Then at 11 a.m., like I mentioned before, we're going to have a brainstorming session, and we'll first hear from Makalika about the National Native American Bar Association's approach to this request for comments. And of course, we'd like to hear from you about your responses and ideas about how you plan to engage with the process. Then we'll take a lunch break. We'll have an hour and a half to do that, and we'll return at 1:30 Mountain Time for a panel on the specific international instrument that's really moving quickly through the diplomatic conference process, one that's focused on genetic resources and traditional knowledge. Then at 2:30, we'll have our second opportunity to talk about our talking point strategies and ideas during a brainstorming session all about this draft instrument. And then we'll end the day with just a brief conversation amongst all of us about where we go from here. Specifically, we'll be asking what outcomes tribal leaders are hoping to achieve through all of this consultation and commentary. So we'll go ahead and jump right in since we have this panel starting at 9:15. I'll just go over some basic vocabulary and we'll dive right into our first panel. So when we think about traditional knowledge and traditional cultural expressions and genetic resources, there's quite a bit we could talk about. I'm going to put up here just some of the definitions that I was able to glean from the World Intellectual Property Organization's website. According to WIPO, traditional knowledge means knowledge, know-how, skills, and practices that are developed and sustained and passed on from generation to generation within a community. And it often forms a part of a community's identity. So you might think about agricultural techniques and technologies. Maybe you might think about knowledge about how to prepare medicines or forest management techniques, as we've seen many California tribes asserting their rights to those. It could be hunting and fishing techniques, architectural techniques, right? A lot of different things could fit into this broad definition. Again, none of us are stuck with this definition, but this is the way that folks have been talking about this for some time. We also have a definition of traditional cultural expressions, again, a very general definition. Expressions of folklore sometimes is used. It might include things like music, dance, art, designs, names, signs and symbols, performances, ceremonies, architectural forms, handicrafts and narratives, and other kinds of artistic works, right, or cultural expressions. Certainly oral histories, dance, ceremony, symbols and designs could fall into that kind of a category. And then finally, I also want to mention just intellectual property in general, kind of a big catch-all category, refers to creations of the mind and also inventions. Could be literary and artistic works, designs, symbols, names and images. Those types of things will be within that package when we talk about IP. All right, so I also want to explain that our tribal nations have quite a few of their own forms of intellectual property. I want to point to a recent article published by Angela Riley in the Michigan Law Review, which documents and catalogs many of our tribal nations' own intellectual property laws. Indigenous peoples have had intellectual property probably for millennia, right, for many of us. And those particular kinds of intellectual property are really important and long-lasting. And so, we certainly shouldn't ignore those when we're talking about intellectual property. These forms of protection are very important and critical to uphold. We should probably also talk about the kinds of intellectual property that we might see out there in the global information economy, right? These are the types of terminology that we might hear being used by the USPTO to explain what they think is intellectual property. So first we have patents. Patents protect inventions or functional designs of things or new plant varieties. You think about your iPhone, it's got all sorts of patents in it, from the technology that runs the layout to the layout of the screen. It could also be vaccines and medicines, GMOs, right? Protection on patents is relatively short, only 14 to 20 years, depending on the type of patent. And recently, tribes like the Tulalip tribe and many others have been investing in research and development, patent portfolios, and many of them have been demanding patent ownership for new inventions generated by that research. Trademark protects things like brands and logos, product names, products designs that are it might just be for fun, or even colors or scents, things that help you distinguish one product or a service from another. The protection lasts forever, potentially, until you stop using the symbol or design, the various kinds of marks that you've created. Recent examples of litigation in this area include Sealaska Heritage Institute's suit against Neiman Marcus. Neiman Marcus allegedly appropriated the Raven's Tail name and the design of a coat created by famed Alaska Native artist Clarissa Rizal. The name Raven's Tail was claimed as a trademark. The coat design was also claimed as a copyrightable work. And the case ultimately settled. We don't know what the outcome would have been, but importantly, tribes are defending trademarks in their traditional creative expressions. Copyrights protect original creative expressions. Think about music and film and dance and theater and books. It doesn't protect facts and ideas, and it only lasts for the life of the author plus 70 years in most cases there. An example of a copyrightable work might be recordings made by anthropologists like Laura Bolton, pictured here, who went onto tribal lands and recorded ceremonial songs of many tribes around the country. These songs and the recordings of them could be copyrightable works depending on the different circumstances. Trade secrets are another category. They protect things like formulas and methods and processes that companies use and they keep secret in order to maintain a competitive advantage against other people. Think about the recipe to Coca-Cola, or maybe Google's search algorithm, or maybe even the definition of a New York Times bestseller. Presumably, certain kinds of maybe agricultural techniques and information, or recipes, or pigments and dyes, or techniques for managing resources, if kept secret and if they offer a competitive advantage, might fall into this kind of a category. And then last but not least, we have rights of publicity. This protects your name, your image, your voice, sometimes your signature in some cases, sometimes your idea, a lot of things that can be lumped into your identity. Protects them from being used commercially without your permission. One example in recent news was the example of Lakota Chief Crazy Horse. His descendants sued Hornell Brewing for misappropriation and misuse of his identity. The case ultimately settled again, but this is again another type of intellectual property protection. So these are the kinds of intellectual property terms we might hear get bounced around today in the different conversations we're going to have. And certainly we'll hear about them probably from the USPTO during consultations and in different conversations. So we wanted to give a quick primer on that. All right, so now we're going to go ahead and head into our first panel. So we're going to get that set up here. But before we do, I wanted to just mention a little bit about what the U.S. Patent and Trademark Office is. The Patent and Trademark Office is the federal agency that's there to help register trademarks and grant patents. It also advises the president and also the Secretary of Commerce and various government agencies on intellectual property policy and protection and enforcement. The goal of the Patent and Trademark Office, or at least their mission, according to their website, is that they're supposed to be providing stronger and more effective IP protection around the world. And it's also there to represent the US in negotiations over international agreements. The Patent and Trademark Office does quite a bit to educate and build capacity in various areas of IP. And I want to recognize that the Patent and Trademark Office has done quite a bit in the recent last few years and over the course of time being at WIPO, but also we've had quite a bit of interaction over the last year or two with tribal nations. And so I certainly want to commend them for all of those efforts. All right, so I think we'll go ahead and now transition to our first panel. We're going to be talking about the current moment. We're going to give an overview and tribal implications of the negotiations at WIPO. So I'll go ahead and invite our guests for this panel to go ahead and start their screens. In this panel, we'll get an overview of the World Intellectual Property Organization and the Intergovernmental Committee that's looking at these topics. And we'll learn about the status of the current negotiations. We'll also get some tribal perspectives. So I'm joined now by our presenters, Sue Noe, Senior Staff Attorney at the Native American Rights Fund and Co-Director of the Implementation Project, and Aaron Jones, who's a Treaty Rights Policy Analyst in the Treaty Rights and Government Affairs Department and the Natural and Cultural Resources Department for the Tulalip Tribes of Washington. So I'll go ahead and stop my share here and go ahead and turn the time over to you both.
Thank you, Trevor, and thanks so much to ASU and you, Trevor, for all the work that you've done putting together this webinar today. I also want to thank everyone for joining us today, and I'm going to jump right in and give a brief overview and update on the current status of the negotiations at WIPO. So I'm going to share my screen and bear with me here. Still learning how to walk and chew gum at the same time. So first off, what is WIPO? Whoops. Like I said, there we go. So what is WIPO? So WIPO, the World Intellectual Property Organization, is an agency of the UN. The UN currently has 17 agencies, with UNESCO, the World Health Organization, and the World Bank being some of the others that you may have heard about. These agencies are a way for the UN member countries to coordinate their efforts in certain areas. Presently, there are 193 nation states that have signed on to be members of WIPO, including, of course, the US. WIPO is based in Geneva, Switzerland, and that's where the negotiations we're talking about today take place. And this is a photo of WIPO's headquarters there. Among its functions, WIPO provides a forum for member states to negotiate new international intellectual property law treaties. And of course, that brings us to the focus of the webinar today, the USPTO tribal consultation on the negotiations presently taking place at WIPO on potential legal instruments for the protection of Indigenous peoples' traditional knowledge, which I'm going to refer to as TK, traditional cultural expressions or TCEs, and genetic resources and associated traditional knowledge or GRATK. So the negotiations we're talking about take place in a special intergovernmental committee referred to as the IGC that was established by WIPO in 2000, specifically for the purpose of looking into intellectual property issues associated with TK, TCEs, and GRATK. Since 2000, member states at WIPO and the IGC have been engaged in text-based negotiations on potential legal instruments. So presently, there are 3 separate texts under negotiation, one for TK, one for TCEs, and one for GRATK. So these are multilateral negotiations with countries, member states of WIPO participating. The negotiations, the countries are organized into negotiating groups. For example, the Africa group, the Asia Pacific group, and the group of Latin American and Caribbean countries. And this is for the purposes of coordinating their positions. You can imagine with 193 member countries, the negotiations would be very cumbersome if each country had to give its position separately. The US is part of what's known as Group B. Group B has 32 members, most being what are considered to be developed or high-income countries, such as Switzerland, the UK, Germany, France, Canada, Australia, New Zealand, Japan, and South Korea. Although they're part of the same group, the countries within Group B don't always agree with each other. For example, Canada, Australia, and New Zealand have been significantly more supportive of the positions of the Indigenous caucus in the negotiations than has the US. So how do Indigenous peoples participate in WIPO? Indigenous peoples from around the world participate in the negotiations individually as observers and collectively as part of an Indigenous caucus. Industry groups and other stakeholders also participate in the negotiations as observers. In general, in these negotiations, we can say that there's been a lot of disagreement among member states, including about the very legal nature of the instruments being negotiated. Some countries want the IGC negotiations to result in binding international treaties that will provide effective enforceable protections, while other countries, in particular the US, are reluctant to change the status quo and would prefer at most some type of soft law or non-binding outcome to the negotiations. My organization, the Native American Rights Fund, or NARF, represents the National Congress of American Indians, or NCAI, in the WIPO negotiations. So NCI's involvement began in 2016 when the Tulalip tribes introduced a resolution at NCI's annual convention about the WIPO negotiations, and in particular, the need for the U.S. to begin formal government-to-government consultation with tribes regarding the positions being taken by the U.S. in the negotiations. The Tulalip tribes, and Aaron Jones from Tulalip is going to be speaking here in a minute, were involved in the work at WIPO from the very beginning of the IGC. And what they had observed is the U.S. taking positions in those negotiations directly contrary to the rights of tribes. Specifically, the 2016 NCI resolution notes that the U.S. in its positions and text proposals was asserting that the majority of Indigenous TK and TCEs are already in the public domain, meaning free for use by anyone, and that the U.S. has the authority to unilaterally abrogate or diminish tribal sovereignty and authority by subjecting TK and TCEs to access and use without free, prior, and informed consent and in contravention of tribal treaties and other federal laws. So the 2016 NCAI resolution called on the U.S. to engage in tribal consultation and to ensure that tribal sovereign rights and authority over TK and TCEs be recognized and protected by the U.S. in its negotiation positions. And then 6 years later, in 2022, with formal tribal consultations still not having taken place, and the U.S. still taking positions in the negotiations detrimental to tribes, NCAI passed another resolution reiterating the call for consultation. So that brings us to where we are now, with USPTO holding what it characterizes as formal tribal consultation. And I think the next panel, and then later on this afternoon as well, we're going to really delve into the nature of this effort by USPTO and whether this is really the kind or quality of consultation NCAI was calling for in its resolutions, or that tribes are entitled to. So now I'm going to talk a little bit about why this is important to tribes. So I think as we look at this and think about the consultation, it's important to keep in mind what's at stake. And Trevor, of course, alluded to some of this earlier. Even though we have recognition in the UN Declaration on the Rights of Indigenous Peoples of the right to maintain, control, protect, and develop TK, TCEs, and genetic resources and associated TK, as well as associated intellectual property rights in those. And then also, of course, we have the Declaration safeguard of free, prior, and informed consent. But in the absence of binding legal protections, TK, TCEs, and GRATK are still in large part being treated as being in the public domain. And we see that there's widespread and ongoing misappropriation and misuse of things like medicinal plant knowledge, indigenous languages, designs, stories, songs, dances, and ceremonies. So Trevor mentioned as well Angela Riley's recent article. So I want to acknowledge and highlight the important role that tribes' own laws and protocols play in advancing protection of TK, TCEs, and GRATK. And of course, Professor Riley's article surveys tribal laws in this area, and I commend that to you. A successful outcome to the negotiations at WIPO can provide another tool to be used by tribes in their efforts. If one or more binding treaties come out, even if the U.S. doesn't initially sign on, like how it initially opposed the UN Declaration on the Rights of Indigenous Peoples, advocacy by tribes and others, and embarrassment from being out of step with the world community can ultimately, hopefully, pressure the U.S. to take positive action. Now I'm going to give a little background about the USPTO and its role in the negotiations. So Trevor also already touched a bit on this, but the USPTO is the lead negotiating agency for the U.S. in the negotiations, having been delegated lead negotiation authority by the U.S. State Department. And so as Trevor was describing some of the functions of the USPTO, USPTO is located within the Department of Commerce. It's the federal agency that grants patents and registers trademarks in the U.S. And the stated mission of the USPTO is to drive U.S. innovation, inclusive capitalism, and global competitiveness. In the international arena, it describes that it works to further effective IP protection for innovators and entrepreneurs worldwide by working with other agencies to secure strong IP provisions in free trade and other international agreements. So I think it's important to understand the worldview that the USPTO negotiators are coming from. And in general, that's a worldview that's very focused on economic factors, the granting of exclusive rights that lead to wealth generation from innovation and creativity. And that's, of course, very different from someone trained in and having a background in tribal treaty rights, tribal sovereignty, and Indigenous peoples' human rights recognized under international law. So there's a huge contrast between tribes being recognized as having sovereign rights over their TK, TCEs, and GRATK, and considering them mere stakeholders whose interests must be balanced within the IP system against the interests of potential users of TKTCEs and GRATK. The USPTO does explain, however, that its positions are taken in the negotiations, the ones it's taking are developed in consultation with other federal agencies and departments, including the Department of the Interior and the State Department. And USPTO does have a tribal affairs liaison, although she's only rarely included in the delegations that attend the WIPO negotiations. As Trevor was alluding to, the USPTO has engaged with us. So in the past, USPTO engaged in a number of listening sessions at NCI meetings, and in recent years has routinely met with the US members of the Indigenous Caucus during the negotiations in Geneva. However, these aren't, of course, a substitute for formal government-to-government consultation. It also bears noting that NCI's resolutions in 2016 and 2022 didn't just call for tribal consultation with USPTO, but also with the State Department and any other agencies involved in the WIPO negotiations. But to date, we aren't aware of any plans for those consultations to happen. So now I'm going to conclude with a brief summary of the current status of the negotiations. So this slide is meant to depict the flow of how the negotiations move forward. The technical negotiation sessions, the ones that have been happening since 2010, take place in the IGC. Then every year, the IGC reports on its progress to the WIPO General Assembly. And then the General Assembly takes stock of the progress made and can decide whether to convene a diplomatic conference, which takes the negotiations out of the technical work in the IGC and elevates them to the diplomatic level. So that's one possibility. The alternative then is for the General Assembly to say that the negotiations should just go back and continue in the IGC. A diplomatic conference is a high-level meeting where diplomats, ambassadors from member states engage in negotiations to finalize and adopt an international instrument. So it's the generally accepted step for concluding a treaty at WIPO. A significant and rather unexpected development happened in the genetic resources negotiations at the WIPO General Assembly's July 2022 meeting. Acting on a proposal put forward by the Africa Group, the General Assembly decided to elevate the genetic resources negotiations to the diplomatic level by convening a diplomatic conference on these by 2024. The decision also included that there be a special session of the IGC held prior to the diplomatic conference to allow member states an opportunity to reach agreement on further refinements to the genetic resources text. And that special session took place in September of 2023. So the diplomatic conference on genetic resources is now scheduled to take place May 13 to 24 in Geneva. So this is a very major development that brings us to possibly the very end of the negotiations on the GR's text and highlights the critical importance of providing tribal input to the U.S. on these negotiations. Even though USPTO's most detailed questions about the GR's negotiations, as we'll see, are in the public comment notice and not in the tribal consultation notice. We'll be talking a lot more about the diplomatic conference and the key issues in the GR's negotiations this afternoon. So regarding the TK and TCE's text, those for now remain under negotiations in the IGC. Under the mandate and work program for the IGC for the 2024 to 2025 biennium, there'll be one negotiation session on TK-TCEs in December of this year, and then two more sessions next year in March and June. In July 2025, the WIPO General Assembly will take stock of the progress made on the TK and TCE's text and decide whether to convene a diplomatic conference on either or both of those, or whether to continue those negotiations in the IGC. And I should also mention that the chair of the IGC has been developing her own chair's text that combines TK and TCEs into one text, and we'll have to see what evolves with that and whether it gains traction with member states during this biennium. In the GR's negotiations, the creation of a chair's text by the former IGC chair Ian Goss played a pivotal role in progressing those negotiations to diplomatic conference. Without a crystal ball, I don't think anyone really knows how the diplomatic conference on GRs will play out and what impact the results of the diplomatic conference might have on the TK and TCE's negotiations. If successful, the GR's diplomatic conference could energize the negotiations on TK and TCEs and lead to more progress being made there. In any case, in all these negotiations, the U.S. must be developing its negotiation positions in regular, robust, and meaningful consultation with Indigenous peoples who are the holders and guardians of these aspects of their cultural heritage. So that concludes my presentation, and thank you very much for your attention. I guess I'll turn it over to Aaron Jones now from Tulalip.
Thank you, Sue, and thank you, Trevor and Makalika, and thank you everybody for being here. Asdatitut, Techop Kedab Tidstat, Walchad Tulalip, Dokol Buf Chud. Good morning. My name is Aaron Jones. Traditional name is Techop Kedab, and I'm at the Tulalip Tribes as a treaty rights policy analyst in the Treaty Rights and Government Affairs Department. I've been attending the WIPO IGCs since 2022, once they started being in person again for negotiations. And so I'm going to try and pick up where Sue left off with, talking about the process of WIPO IGC and just talking about, kind of Tulalip's experience and, the current friction points that we're seeing currently in the negotiations of all three instruments at a high level. Because as the day goes on in this webinar, there's going to be more specifics that are kind of analyzed and talked about, especially in the afternoon when it comes to the strategizing for talking points. And you can see my slide, okay? Okay, perfect. I just wanted to make sure. It always looks different once I start sharing screen. So just a really brief snapshot of Tulalip's involvement at WIPO IGC. So back in 1999, there's the word that the WIPO IGC was going to be established in 2000, and at that time we had our late elder Terry Williams, along with former colleague Preston Hardison at the Tulalip Tribes, beginning to attend WIPO IGC, and Tulalip got officially accredited as an observer at the WIPO IGC back in 2002. And from there, we've kind of had attended regularly, as well as, you can see some of our history of getting NCI involved with the resolution. And so it's been a lot of years. And I think, as you can note within this, there is no mention of a consultation with the USPTO and US delegation regarding WIPO IGC. And so it's now been over 23 years and we're into 2024. So this is a new reality that we are starting consultations at a point where much has been discussed. And I think a lot of momentum that could have been built in the past 20 years of, consultations and regular outreach to tribes to help build capacity and understanding these negotiations in this area could have occurred. But we're at where we're at now. But this, preparation webinar is beginning, and we can, continue building together. For the Tulalip Tribes, the reason, there's many reasons why we attend. WIPO IGC. Major risks include, the potential loss of our right to, utilizing our art, story, literature, craft. Our songs or dances if they're recorded and in some way copywritten or trademarked. A major reason we got involved is, of course, through genetic resources. Tulalip has long attended the UN Convention on Biological Diversity through Terry Williams and Preston Hardison's participation. And so this was a key interest of just trying to find ways to explore protections and safeguards for our genetic resources, as well as our, now what we call traditional cultural expressions, which includes those songs and those dances. And there are many secret and sacred, knowledge, or sacred objects that we don't want to end up in the public's hands, for either mass production to be sold in Walmart or for other kind of exploitation that we can see, whether it's through our medicinal plants, being exploited for, big pharma. And it's just it's a good opportunity to find, at a high level at the international, in an international treaty, finding those safeguards that we can then implement at a domestic level with the US that we don't currently have. And there's another additional risk to our tribal sovereignty and governance. As Sue mentioned, the UN Declaration on the Rights of Indigenous Peoples, and I think it's going to be talked about more later this morning as well. Indigenous peoples have self-determination as tribal nations. We have sovereignty and that self-determined right of governance, whether that's through tribal codes, other indigenous laws, or customary laws and protocols. For a lot of spiritual and sacred ceremonies or teachings or stewardship of songs and dances. At least for my tribe, there are customary laws and protocols that aren't written that have been passed down from generation to generation, and since time immemorial. It is unique to families. It is unique to tribes, and there are many risks that some of these ceremonies end up becoming inappropriately disclosed or in some form or fashion trademarked or copyrighted if the dance is recorded and someone wants to put it in a popular video game to trademark a dance move or an emote, as they call them. But it's an important aspect that I think for this consultation that any tribe can speak from their point of sovereign, self-determined sovereignty positions, because each of our sovereign rights are unique to our own tribes. And that's important to highlight, I think, in these consultations with the USPTO and the Department of Commerce. And I know that one of the main questions for this consultation talks about, how do tribes, govern their TK and TCEs, and to the extent that I think that tribes want to, fully divulge, their customary laws or protocols or tribal codes, like that's up to each tribe. For the Tulalip tribes, it's going to be kind of threading the needle of, what's okay to disclose and what's, too much information, because at the end of the day, as a sovereign, and there needs to be that recognition and that right for each individual tribe that there's a government obligation from the federal trustee to consult if there is a potential implication to your rights in any kind of decision making capacity. And so again, in these international instruments at WIPO, we want to safeguard and protect, from inappropriate disclosure, misappropriation, and overexploitation, or any type of inappropriate exploitation as well, misuse and harmful use of PK and genetic resources associated with traditional knowledge. And what we're looking for in each of these treaties, when we go to the negotiations, each session generally covers a different treaty. With the diplomatic conference, it's only going to be covering genetic resources. With other IGCs sessions, there's going to be covering just PK and TCEs, possibly bilaterally, in general, bilateral or just on their own. But in each of them, the Indigenous Caucus and Tulalip aligns with this, and I think with NARFN and CI, as well as looking for a sui generis regime, these WIPO IGC instruments. What is sui generis? I guess we should clarify that. What I gathered from just this definition from the Cornell School of Law, sui generis is a Latin expression that translates to of its own kind. It refers to anything that is peculiar to itself, of its own kind or class. Legal context, sui generis denotes an independent legal classification, and within these instruments, we want Indigenous peoples' traditional knowledge, traditional cultural expressions and GRs and associated traditional knowledge to be, not treated as just other intellectual property law. There needs to be ways that it is protected. And it needs to be unique to each tribe and indigenous peoples of the world. When it comes to domestic implementation here in the U.S., it is going to be based on, that government to government between a tribe and the USPTO and what is the appropriate protocols or, appropriate procedures for treating TK or TCP if there is an application that has usage of a tribe's TK or TCP. And then in addition, what we want from all these treaties is the use of, for these treaties to be, adopted as a hard law binding treaties. Sue mentioned, the difference between soft law and hard law a little bit, and U.S. delegation has regularly pushed for these WIPO IGC instruments to be soft law. And the risk with that is we don't get that, that appropriate level of, hard law, I guess, the teeth that we need within this instrument at the domestic level to hold the U.S. accountable for any kind of, authorization of misuse or misappropriation of tribal TK or TCBs. And in addition, the U.S. has regularly suggested that there should be an international toolkit of guidelines that comes from WIPO IGC rather than hard law treaties. And it's the general stance that we have seen at the Indigenous Caucus that that's not enough for safeguarding and protecting tradition Indigenous peoples, TK, TCs, and GRs. So in addition, we also want to see sanctions and remedies in these instruments. If there is going to be an exploitation and inappropriate use of Indigenous peoples' knowledge, so I showed a drum in an earlier slide as an example of a TCE. So if these drums were going to be exploited in a way, mass marketed without consultation and it's very specific to a tribe, we want to ensure that there are sanctions for that type of activity when that Tulalip would find is a misuse without consultation of if that's really what the tribe wanted or not, regards to our TCE. TK usage. In addition, at the WIPO IGC, all of the instruments generally have exceptions and limitation articles as potential articles included in the treaties. We have a general stance of not wanting the exceptions and limitations in the international instruments. That is largely because there should be free prior informed consent before TK or TCE or genetic resource associated traditional knowledge is utilized for some form of exception. And generally, I think I've noted that there has been pushes for research institutions as well as private industry to be able to be exempt from having to go through appropriate consultation with tribes or indigenous peoples in the usage of TK associated with genetic resources or TCEs. So at the end of the day, we just want to make sure that here in the U.S. that tribes would always be consulted regarding any kind of usage that's applied for at the IP level, IP system level. The U.S. delegation frequently pushes for public domain to be also included into international instruments at WIPO IGC. I mean, I think if growing up in the U.S., you might hear of public domain constantly used, and I know there's attorneys in this webinar that can expand on it more. I'm a policy analyst, but maybe big news you might have seen on New Year's Day that Steamboat Willie Mickey Mouse is now in the public domain. So, and that took many years in congressional legislation that extended that right to be protected, but those type of efforts are not generally afforded to tribes TK or TCEs, and we're at a point where there's a general assumption if we've seen a song in a public park, if that song is recorded, then it's in the public domain because we're at a public park. And that is something that we don't agree with, because under at least from the Tulalip perspective, under our traditional laws, customary laws and protocols, that song is still stewarded by a family. It's still stewarded by someone that it was passed down to by elders and by their ancestors as well. And so we just want to, kind of debunk the notion that there is a public domain when it comes to our TK, TCEs, and genetic resources and associated traditional knowledge, because it's stewarded into perpetuity, unless first, it is agreed by the collective of the tribe, through our governance that we self-determine this knowledge to now be in the public domain. That would be very explicit and really prescribing it to that notion of the public domain. But by and large, in Tulalip, like I haven't seen that happen within our tribal council or within our community as well. So we just want to make sure to the U.S. delegation and to the USPTO that in this consultation we're going to communicate that the public domain doesn't apply to our TK and TCE. And I think this could be discussed further today as well. So that was kind of just the gist. I kind of rolled through it really quickly because I wanted to make sure we had time for questions, because some questions were popping up. And Sue, I do want to invite you to if there's any additional points that you wanted to add.
Thanks, Aaron. Yeah, just to really highlight your points about the public domain, because that is something that the U.S. Pretty regularly brings up and, as you say, talks about in the consultation notice. And one thing that the caucus has said about public domain in the negotiations at WIPO is that to focus on protection of the public domain would be essentially legitimizing hundreds of years of theft of Indigenous peoples, TK and TCEs. And to me, it's somewhat analogous to Aboriginal land rights and that sort of thing, where the dominant legal system, the colonial system, was not recognizing existing forms of Indigenous land tenure and considering that the land was available. So these things are not available. They're governed by Indigenous people's own laws, and those need to be respected. So yeah, let's see what Q&A we have. I don't know, Trevor, are you moderating the Q&A, or how should we proceed?
Sure, I'd be happy to read a couple here. The first question that we have in the queue of questions from Marcos Aguilar says, given the international nature of this area of Indigenous peoples' rights, how does this specific discussion address the rights of non-federally recognized nations or tribes, migrant Indigenous peoples, and also the possible pluricultural nature of some IP among tribes, especially transnational contexts like Kokopah and Kukapa? I'm not sure how you pronounce that, but would either of you want to take that question?
I'm happy to give a first go at it. So if you want to go for it too as well. So I think, under the UN Declaration on the Rights of Indigenous Peoples, if, collectively you self-identify as Indigenous peoples, you're Indigenous in that sense. And to the extent that that applies domestically, it is subject to legislation at the congressional level. I think state law can be slightly different. So I won't go too far into that one, I don't think. But as far as the transnational context, as a Tulalip tribal member, I'm also, so I'm not a descendant, I'm Snoqualmie, Wenatchee, Cowichan, Duwamish, Saanich, and among those, there's I'm 1/4 Canadian on my grandma's side, First Nations, and Cowichan, and Saanich side. And so there are certain songs within my family that are stewarded and passed down to me and my relatives here in the US that are actually stewarded still by the elders there in Canada. So there is that kind of transboundary issue that we do have, of different type of treatment that we could potentially see between protections here in the US with my family, and then different protections up in Canada, for the same songs potentially. And so with that, in the treaties, there are articles for transboundary agreements between nations, and I think that would be very appropriate if the US and Canada had a transboundary agreement made in conjunction with tribes and with First Nations about how we'd like to see protections for these areas of plural cultural nature as raised in the question.
Wonderful. Sue, did you have any thoughts on that or? Okay. I noticed that we have Preston Hardison actually joining us. He's raised his hand, and so I thought I'd give him the floor for a second to share his thoughts. Preston, I'm going to go ahead and turn on your your mic here. All right.
There we go. Thank you. Yeah, I just wanted to, these are excellent reviews and presentations, and I just want to applaud everybody for making them. I wanted to make comments on a couple of things. One, I wanted to point out on the Dennis Hayes, on Aaron Jones' timeline, we did have a back and forth with Dennis Hayes, and the TLELIP does have a copy. I imagine it's in the that is maybe in the public domain since it's a formal communication from the U.S., but I'm sure TLELIP would be happy to share it. There's a letter from Dennis Hayes that says, "It is the understanding of the United States that tribes have the right to pass legislation to protect their own traditional knowledge." And I think that's an important statement. Now, the statement didn't say how far that right reaches. Of course, TLELIP did a review with University of Colorado at Boulder a few years back, because we asked the question, is there any record on the congressional record of the termination or abrogation of tribal rights? And it's our position that traditional knowledge, traditional culture expressions were, and genetic resources were never covered in the treaties. They weren't even thought of in the treaties. And so they could not have been ceded or negotiated away by the tribes. They would have been a core aspect of what the tribes wanted to protect. And so it is an inherent reserved right from our position. So just like human remains, we believe that the right extends beyond tribal territories. So there's an extraterritorial dimension within the United States. And then this also should extend to any treaties that the United States negotiates with anybody else. The final thing I want to point out is that there's two ways to look at the WIPO process and the intellectual property system. What the US is doing is they're trying to find in the margins, protections through the intellectual property system. So what can we do using the existing intellectual property system to protect traditional knowledge? And that's what we really, I think, should focus on in the conversation with them, because we have always said we're here for sui generis protection, which also includes protection from the intellectual property system. Now, there's a lot of debate on whether this is the proper forum for the traditional knowledge, traditional culture expression, and genetic resource discussions. In some ways, it is absolutely not. It just got put there because of different political forces, international forces in 1990s. But at the same time, the intellectual property system has to respond to indigenous rights. And so again, when the US is going to kind of offer all these kind of marginal protections in the existing system, and we really need to say, no, for example, we have permanent protection for knowledge and expressions that were never ceded, and genetic resources that were never ceded to the United States and were never ceded to anybody. So anyway, I just want to make those comments. I hope they're useful, and thank you for allowing me to speak.
Thank you, Preston. We appreciate that. Let's go ahead and I think Makalika had a couple of points to add.
I was just going to pitch in on the question from Marcos, but I think Preston actually added a lot of what I was going to say, which is that I think the question Marcos was asking about how this works if you're an indigenous person whose ancestral territory is outside of the US, and what happens when your nevertheless cultural property or traditional knowledge is being misused or abused in the US, and sort of the complexity of the circumstances that I think would be involved in analyzing what could be possible in that situation. I think Preston hit on really well, because it gets to things like, well, what's it's extraterritorial, so who's what would be, there's the international policy, but part of what I think is happening here, to Preston's point about the US trying to figure out what they can do within the intellectual property system, is the US trying to figure out not only what this instrument would look like, but they're also trying to forecast how would they then implement their obligations under such an instrument, right? So coming up with language, the instrument's going to be broad, and then all of the participants are going to have to go back to their countries and actually implement enforceable law within their court systems to figure out what that really means. And so we're really at the beginning of what's going to be a very long process to come up with anything really concrete that people can then have the force and effect of law to use. Before you get through that multi-step process, you're going to have a lot of diplomacy that can be effective depending on how significant the issue is, but it puts a lot of burden on the indigenous people, which often don't have the resources to launch and compete for attention using diplomatic means, right? So we know that in the trenches, when our intellectual property, our traditional knowledge, our cultural intellectual property is being abused, it's hard if you're depending on diplomacy. And it's also going to depend on who's doing it. Is the violation a direct action by a government, or is it a direct action by a private party? And so you're asking the government, who has some sort of jurisdiction over that party, to go and stop that private party from doing something. And then it's even harder when you're depending on diplomacy. You really need to have law that has force and effect in a court, I think, to get a practical outcome there. So I think it's a really good question, Marcos, and it helps illuminate how complicated this is for actual traditional knowledge protectors, practitioners, and stewards. But it also signals how important it is that we all lean in and participate in this, because there's so much work to be done. When we can get government to actually put some energy into it, they need to see through the volume of our participation that it's important.
Thank you, Makalika. I wanted to just make sure that everybody received the link that I just sent out. I sent it out through the chat. Hopefully it made it to all of the attendees as well, about the current language that's going to be used at the diplomatic conference on this GRATK instrument. If you didn't receive it, if somebody would just put that into the chat or the Q&A, I'll go ahead and put the link in there as well. We have a couple more questions here. Let's see, you have a couple more from Marcus. I have one from Stuart Koyamtewa. He says, is there a way to revisit items and or cultural terms that are now part of the public domain, such as katsina being used on merchandise such as alcohol? Any thoughts on that from Sue or Aaron?
Sure, I can jump in. One of the points of discussion in the negotiations is the retroactive effect, right? And so the position that the majority of member states has taken is that there shouldn't be a retroactive effect. So the way that the instruments are structured right now, there wouldn't be that. It would be sort of forward looking and not remedying past harms. There is, in the current draft of the TK and TCE's text, though, this possibility to petition for recognition by a country that in national law that something that is considered to be in the public domain, or something that's already being utilized, that it be moved into a higher status of protection. And maybe Aaron or Preston might want to say more about that, but mostly this is forward looking and not looking to remedying the past, which of course doesn't meet the standards that set out in the UN Declaration on the Rights of Indigenous Peoples, Article 12, which addresses some of that.
All right, well, I think we're at time now, so we're going to go ahead and first of all, thank you, Sue and Aaron, for the wonderful presentations, and all of you for the responses and questions, Makalika, Preston, and those of you that have participated so far. We're going to go ahead and invite our next roundtable participants to join us, join the conversation, and we'll take just a quick 1-minute break, and then we'll be right back with you. Okay, so we'll now begin our Scholar Roundtable entitled Making Sense of the USPTO's Request for Comments, where we'll take a closer look at the process that the USPTO has selected for engaging with tribes on these really complex and sensitive issues, as we're just talking about. So I'm joined today, graciously, by Kristen Carpenter, Council Tree Professor of Law and Director of the American Indian Law Program at University of Colorado Law School and co-director of the Implementation Project. I'm also here with Rebecca Sosi, Regents Professor and Morris K. Udall Professor of Law at the James E. Rogers College of Law at the University of Arizona, and Lauren Van Schilfgaard, Assistant Professor of Law at UCLA School of Law. Welcome, all of you, and thank you very much for being willing to join me today on this roundtable. Let's start with a question here. You know, in my experience, most people haven't worked directly with the U.S. Patent and Trademark Office, unless maybe you're an inventor, a business owner, perhaps an attorney. We talked just a little bit about how the USPTO handles patent filings and trademark registrations, but it also has its hands in these important international agreements. What are the USPTO's obligations, though, to tribal nations and their laws as a matter of federal Indian law and policy?
To speak, or I'm not sure if we decided.
Feel free to chime in. I know you all have really interesting and wonderful things to say. So, yeah, Kristen, go ahead.
Okay, thanks so much. And thank you to ASU and all of the fellow organizers and hosts and audience members. It's really a pleasure to be on with all of you. And my sense is that USPTO, as Sue said earlier, has been largely driven by its intellectual property law mandate. And yet, like any agency of the federal government, it is bound by its trust responsibility to tribes and all of the treaties and statutes and regulations that require the United States federal government to protect tribes' resources, rights, and interests. And so while federal Indian law, federal Indian policy around Indigenous peoples' resources hasn't been yet front and center of USPTO's positions in the WIPO negotiations, that's a mistake. And that's a fundamental omission in the agency, like all agencies, duties to tribes. To be more specific, I think that Preston and Aaron and others mentioned that there may be obligations growing out of treaties when, for example, tribes reserved fishing rights or hunting rights or habitats. Those may well have included and almost certainly did the genetic resources and the traditional knowledge that was, as part and parcel, that is indivisible with those resources. And so my perspective is that the federal government, all agencies of the federal government, have an obligation to protect those in every instance where they have an opportunity. You could say same with the federal Indian trust responsibility. The government has an obligation to protect Indigenous resources with the highest duty of care. And also potentially certain statutes. There are statutes that go to tribes' intellectual and cultural property. We could get into those in more detail. And then I'll just say briefly about international law. And I think other people, Rebecca and Lauren, my dear colleagues, will chime in. But under the International Covenant on Civil and Political Rights, states like the United States, and the United States is a party to that instrument, have a duty to protect persons and people's interests in their resources, to make sure that they benefit from them. Under the covenant to end all forms of racial discrimination, the United States has an obligation to treat all people with equality. If industries and companies and universities have intellectual property protections, so too must Indigenous peoples, including tribes. And finally, several people have mentioned the UN Declaration on the Rights of Indigenous Peoples, which the United States has supported. And it has a number of articles on cultural rights, as well as more specifically genetic resources, traditional knowledge, and cultural expressions that perhaps we could talk about going forward.
Wonderful. Thanks. Thanks for leading out the conversation, Kristen. Any other thoughts, Professor Sosi?
Thank you, Trevor, and thank you, Kristen. That was an awesome way to open it, and kind of going back into the audience participation in the earlier session. And hello to all the esteemed colleagues like President Hardison who've really worked for many, many years on multiple parts of this. There's a complexity that was embedded there that I just want to highlight as we move along. That discussion about what an agency's responsibility is can be addressed within the mandate of the agency, and we actually saw that earlier in terms of the language. But when we think of things like what is the responsibility of the United States as a government to the federally recognized tribal governments of the United States, that's a separate issue that imports those duties and responsibilities, including what we describe as the trust responsibility, but also the obligation to uphold treaties, even if the tribe currently lacked some form of recognition. Maybe they were terminated, they still have some existing treaty rights. So the United States has that obligation, and all of its agencies are assessed with that obligation. That has been one of the hardest things in my career to explain, because people are used to locating the trust responsibility with the Department of Interior, the Bureau of Indian Affairs, but it's really much larger. That idea of property rights is embedded in the country's history. It's in the Constitution, right? Copyright law, trademark law, patent law. To some extent, those have all been federalized, and the US Congress has that obligation to discharge. That's why we have federal intellectual property laws. Those federal laws didn't explicitly refer to tribal governments, nor did they refer to indigenous peoples. So there's a second order of what we're describing as federal Indian law in that old kind of colonial model. But the old colonial model grew up, and now it's the era of self-determination, as many of the colleagues have noted, in the context of the UN Declaration. In my view, and this is just my personal perspective, it's not intended to do anything other than to make us think, there has to be a new era of federal policy around the notion of self-determination that encompasses the technical obligations embedded in trust and treaty rights, but goes beyond that. And the question about what about transboundary indigenous peoples? If you look, for example, at woven baskets by O'odham people, it's on both sides of the borders, that design, the technique, the practice, the plant, it's on both sides of the borders, and you can't qualify that. So this idea of self-determination goes to the people, the indigenous people across what is now the international boundary line, or even a state line, if it's an Arizona-California situation or a New Mexico-Arizona situation. Those colonial derived borders do not interfere with the rights, obligations, and those are human rights. So we have federal technical rights, we have human rights, and then we have this idea of civil rights, and that was what Kristen just described. And I think here I would ask people to really think very carefully about the modes of exploitation that can occur, have occurred, require redress, repair, reparations. That is the discussion that is on the table for nation states, US, Canada, Mexico, in the wake of the appropriation of both tangible forms of property and intangible forms of property. And I'll conclude here, but the intangible category is the most important right now. The public domain is a construct of European consciousness, And that cannot be used to describe these vast domains of protected knowledge that still reside with the indigenous knowledge holders. That is the area that we're talking about. It is an area of complexity, and I hope and expect that the USPTO and all of the entities within the United States are present with that discussion. Thank you.
Wonderful. Thank you, Professor Sosi. Professor Van Schilfgaard, anything that you'd like to add?
No, that was so fire. Except I think this is maybe teeing up to like future questions, but what really occurs to me, in addition to all of like this like expertise, is the process. I think that this is an opportunity that's very specific in intellectual property, but has massive ramifications for general engagement, hopefully, ideally, absolutely for future negotiations for other international instruments. And it's clear, based on like the 23 years of silence and the relatively clunky onboarding for this consultation, that the USPTO, and I think the international face of the United States, is not very good at engaging with Indigenous peoples yet. And so this like is a really important like moment of like starting this consultation, but also like a really important moment for helping to set the stage for what it should look like.
Wonderful. Yeah, thank you very much for that. Well, and piggybacking on to this question about, the impacts on international law and the USPTO's obligations under international law. I know Professor Carpenter raised this, and thinking about what this might do going forward and how the USPTO should be engaging with tribes. Can we dig a little bit deeper into that international law question? What obligations does the Patent and Trademark Office have under international law to Indigenous nations? And how should Indigenous nations approach their comments to reflect this and to emphasize this?
Professor Sosi, not to put you on the spot, but would you maybe be willing to talk about the Convention on Biodiversity and some of the other points that you raised on our preparation? We haven't discussed those yet. Maybe Lauren and I can chime in afterwards.
Thank you, Kristen. I was being deferential in recognition that your program, which is amazing, has co-hosted this, and I want to be respectful of your tremendous leadership in those international forums. But I'm happy to weigh in initially, and I'll refer back to, for example, Preston Hardison, who's in the audience today. There is an instrument, the Convention on Biological Diversity, which entered into force internationally in 1993, and that was from our purposes, and certainly from our students' purposes, that was like a very early point in time. But we could already see the depletion of species that is associated with what we now are calling climate change, and particularly, that caused by, human conditions. So that Convention on Biological Diversity had a Article 8J that referred to benefit sharing, or the duty to engage in benefit sharing. So it pretty much said the nation state holds the title to the land, and this could go back to those discussions of Johnson v. McIntosh in federal Indian law. And therefore, everything within its territory is really under the protection of that government, or they could refuse to protect it if they wanted to, right? So what is a conservation area? The nation state had that claim. To the extent that there was what we are referred to at that time as biopiracy, companies out there, navigating medicinal knowledge of Indigenous peoples in the Amazon or something and trying to craft pharmaceuticals. That provision of benefit sharing said the nation state ought to work with its Indigenous and local communities around those resources to ensure that they do share in the benefits. So what was that? It was an attempt to protect civil rights by enforcing this barrier of non-exploitative action. the United States supported that in principle, but it didn't sign on in any binding way. And the 2010 Nagoya Protocol was intended to establish a framework for implementation of that idea that you had to engage in benefit sharing. Is that discussion even part of what we're talking about today? In my view, the United States has conveniently de-linked its intellectual property rights duties, which are protected under international treaties, because the United States wants to protect its copyrights and patents in other countries. That is a fully enforceable structure, but it has de-linked it from this notion about biodiversity and conservation and benefit sharing. WIPO has pulled that together in this idea of sui generis rights. The genetic resources cannot be patented in their native form, but to the extent that there are products derived from their genetic sequence that are used for adaptation, especially in climate change, maybe they grow crops that withstand, arid conditions, desertification. These are things that could be the subject for genetic modification for new protected plant patents within that structure of commodification. If the associated knowledge is tied to an indigenous community, then it's like the exploitation that happened in an 8J situation. And I have always struggled with the language of WIPO because it is in that idea of kind of a moral duty to share benefits rather than viewing indigenous kind of ownership and control over knowledge and stewardship over resources. And I'm going to leave it at that, because obviously many of the natural plant species are living in non-tribal land areas, right? So they're in other places, but the knowledge is still with the tribal people. Seeds, heirloom seeds that have been tended, there's a practice and there is a tending of those seeds over time by seed keepers, which isn't necessarily going to be recognized in this process, but at least it's a step forward. So genetic resource and associated traditional knowledge are pulling into the domain of genetic resources and conservation, but also in this property-based WIPO structure. So I don't know if that was helpful to where you're headed with the international obligations, but that's what I see.
Wonderful. Professor Carpenter or Professor Schilfgaard?
Lauren, would you like to go on this one so that I'm not hogging the floor? And then I would love to chime in too.
No, please go ahead.
Well, thanks to Professor Sosi for those comments. One reference that I'd like to direct people to, and I think that Professor Reed is putting it in the chat, is a technical review by my colleague and former UN Special Rapporteur on the Rights of Indigenous Peoples, Jim Anaya, who looked at international obligations vis-a-vis the negotiations ongoing at WIPO. And a couple of points that I might like to underscore there. Often in the United States, we think about international obligations as not being particularly pressing or at the forefront of our analysis. And I think here it's important to note that the United States is a party to several international treaties that impress upon it binding obligations as a matter of international law. And the two that I would reference here are the International Covenant on Civil and Political Rights. I mentioned that it has provisions for the protection of resources, the right to benefit from the exploitation or development of those resources, but it also, under Article 27, protects the rights of minorities to have their cultures protected. And of course, there's a lot of interpretive work to do around the idea of minorities versus indigenous peoples. But that treaty definitely protects Indigenous peoples' rights to their culture. And I think we should also note that the UN Declaration on the Rights of Indigenous Peoples, while it's a declaration, gives us that interpretive guidance that we need to understand the United States obligations under those international treaties. And there's a lot of relevant language under the UN Declaration, but Article 31 specifically pertains to the right of Indigenous peoples to their traditional knowledge and their genetic resources, which is, of course, the topic of this treaty that's currently under negotiation. And I was pleased to see that in the draft genetic resources instrument, there is a reference to the declaration in the preamble. And one of the things that I would really like to urge the United States is to be sure to keep that reference in the text when the negotiations are happening at WIPO, because the US has already indicated its support for the declaration, and this helps to bring that interpretive force of the declaration and the way it brings in other treaties that are relevant to Indigenous peoples. It helps to keep those points at the forefront. So I think that's probably enough for the moment, but for people who are interested in more detail, I would really refer them to that review by my colleague Jim Maya. Thanks.
Okay. Well, just to continue on with some of our questions here, one of the major concerns that some folks have expressed with the USPTO's request for consultation and comment on these WIPO draft agreements is how these agreements will treat past appropriations of Indigenous culture and religion and knowledge and creativity and innovation and pretty much everything else, right? How can tribal nations respond to the notice without effectively ratifying these prior illicit appropriations of traditional knowledge and traditional cultural expressions and genetic resources? Maybe we'll start with Lauren. Would you like to take this on?
I don't have a magic wand, but I imagine my colleagues do. But I do think it's an invitation to elevate the role of tribal law. I saw one of the questions talking about, should tribes be thinking about codifying? And I think this came up earlier. I don't necessarily think that this in and of itself is a reason to change whole cloth tribal protocols for how intellectual property is or isn't reflected in the written tribal law. But to the extent that it is, I think that it's a huge opportunity to elevate the role of tribal law as a critical source that should be consulted and referred to. Even if it isn't written down, tribal customary law, to the extent that it is a binding living force within the tribe, is also a relevant source of law. And that to the extent that either written or unwritten tribal law condones or does not condone past prior appropriations, I think that that is relevant. And so I think that it's such a great opportunity to inject into these WIPO negotiations, but also to educate the USPTO that tribes are not just individual stakeholders, that they're not just individuals whose civil rights have been violated, but that they are peoples with sovereignty and law that must be incorporated and acknowledged by the USPTO as a relevant source of law for interpreting whether or not intellectual property is being violated or not. And so when we think about, prior appropriations, how are we going to deal with those? To what extent is redress relevant? Tribal law is going to have a significant role in facilitating that.
Thank you, Professor. Professor Sosi, Professor Carpenter?
Go ahead, Kristen.
I'll say briefly, one of the things that I really love about international human rights law that's often missing from US law is its focus on remedies. So the idea is that states have an obligation to protect the human rights of all people and peoples, including indigenous peoples, and to provide remedies for past harms, and also to prevent future recurrence of violations. So I view this genetic resources instrument, especially in its current form, as articulating the bare minimum of protections for indigenous peoples' genetic resources. And to the extent that, as Sue mentioned earlier, it's prospective in nature, it doesn't have a retroactivity portion, that's a floor. And there is nothing to stop indigenous peoples from pushing the United States when it adopts domestic legislation to go further, to enact remedies for past harms. And in fact, there are many instruments like the UN Declaration on the Rights of Indigenous Peoples that recognize that states do have to remedy past harms. Article 8 of the UN Declaration on the Rights of Indigenous Peoples provides that states do have an obligation both to protect against current violations and remedy past harms. I see that Sue has her hand up, and maybe I've just misstated something that she's fortunately going to correct me on.
Well, I'll jump in now. Not a correction at all, Kristen. No, and I'm really appreciating and loving this discussion. I did want to acknowledge that the U.S. is supportive of including a reference to the declaration in the preamble, and so that's to their credit. I also wanted to mention that I misspoke earlier about the retroactivity. When I referenced Article 12 of the Declaration, I meant to reference Article 11. And I'll just read that really quickly if you don't mind. But it says that states shall provide redress through effective mechanisms, which may include restitution developed in conjunction with indigenous peoples with respect to their cultural, intellectual, religious, and spiritual property taken without their free, prior, and informed consent or in violation of their laws, traditions, and customs. And of course, at the in the outcome document of the 2024 World Conference on Indigenous Issues, you know, the indigenous peoples, excuse me, all UN member states, including the US, in that outcome document committed to working toward achieving the aims of the declaration. And so, you know, something that Kristen and I do, and working with many others in the implementation project, is to try to push the US forward toward compliance and implementation of the declaration. Thanks.
Thank you, Sue, for that. And thank you, Professor Carpenter. Professor Sosi, did you want to chime in on this one?
Yes, and maybe I'll tee it up for your next set of questions, because we've had amazing responses to your initial question. I would like to take it into one step further and look at the process. So the requests for, you know, consultation, quote unquote, it has this long list of questions, weigh in on this, weigh in on that. It's like a questionnaire, right? What do you think about the public domain? What do you think we should do? Get it? And that's like the consultation thing. But then the public notice, we're thinking about doing this. What do you think about sui generis rights or whatever? Like, that's what the public is reading and commenting on, because this is in a federal agency process. To me, that is very significant. And I certainly am not in a position to advise any tribal nations. I'm so glad that NCAI and NARF and colleagues are working on this to actually engage tribal government leaders. But one of the things that I would just personally be concerned about is that you don't want this to turn into some large scale process that results in a really finite moment in which the treaty, the international treaty, then says we shouldn't exploit indigenous peoples. Let's have a database. let's put things in the database and then that'll be part of the patent process. And if you can trace it, then, maybe there's a process to cancel your patent. And somehow GRs and TK and associated TK and traditional cultural expression all become glommed together into this is the only thing that really matters, is to look at the value of that patent. And maybe there's some limited space. All of these questions are basically mining for information about how tribal nations feel about these broad and central categories to protecting knowledge. If there's a consultation like that, that should not take the form of this questionnaire. That is essentially saying, what is the future of Indigenous peoples' knowledge in relation to all of the things that they may want to protect, whether or not they are known at this very moment? Why do I say that? Because the technology in genomic technology, genetic sequencing, genetic modification, the technology is at a very different scale. Artificial intelligence is introducing new notions of knowledge and consciousness and exploration and technology. Is that a world where you can quarantine the things that are held, and I'm going to use the words of our earlier speaker from Tulalip, sacred? Can you protect that in that world? So if there is going to be a consultation, it seems like the main premise is that all is protected. And I believe that's what Preston Hardison was saying their position was at the gate, that all is protected. These rights have never been abrogated or preempted. And now is the time to actually think very consciously about how you want to engage in a consultation, and that is for the tribal governments. For Indigenous peoples, human rights, the discussion is much broader. What Kristen, there are about 5,000 Indigenous peoples globally estimated. That's 5 to 6% of the global population. It is my belief from some report that 80% of the world's biodiversity is on the lands that are occupied by those peoples. So you can see how important that association of people and knowledge to the conservation of these very important plants and resources is. I don't know if that made sense, but that's just kind of the moment that I see.
Well, yes, that made perfect sense, and thank you for that. And I think there is a question that a lot of folks have is, this long list of questions that the USPTO has given, do they presume too much, right? Do they essentially box tribal nations into particular frameworks or ways of viewing the world that are basically economic, or that lend themselves to that kind of approach, that kind of a lens? Some of the questions that we see on the list presume that tribal nations maybe have a public domain or think cultural creativity exists in this way, right? And what should tribal nations do to avoid being boxed in by those types of questions? How can tribal nations capitalize on this opportunity while also avoiding narrowing the scope to just mainstream IP concerns, right? Professor Carpenter, Professor Van Schilfgaard, do you have any thoughts on that?
Professor Van Schilfgaard, would you like to start this one?
This is not the first presumptuous letter starting off a consultation. I think it's indicative that we've never done this before. We don't know. Happening in a context of 20 years of negotiations that have been conducted without tribal consultation. So yes, I think your observation that they're making presumptions about where tribes stand and how tribes are structured. So I would invite tribes there's a couple of different strategies for how to handle these types of letters, just generally, but also in specific regards to this one. But I think starting off with just an open right? Like resetting the stage that tribes have no obligation to accept the terms of engagement that this letter has set out. Tribes, I think, have all the sovereign authority to dictate their own terms and sort of reposture how they see the WIPO negotiations, where they see their own intellectual property framework, where they see their own thoughts on the ways in which their cultural resources, intellectual property have been or have not been acknowledged and protected. I think that would be completely relevant and a huge benefit to helping educate the USPTO where tribes have been, because right now it's just an empty void. I think to the extent that answering some of the questions can help provide some specific guidance and relieve the US government from making assumptions about where tribes stand or do not stand is useful. There's no reason, there's no obligation to answer every single question as it comes up. And so I think that becomes more of like a strategy of where tribes want to engage and where they don't want to engage. But this is like once again, this is a huge lift on tribes to sort of help the US government frame and educate, like, this is what engagement looks like, which I think also sort of touches upon one of the questions about the difference between consultation and free, prior, and informed consent, which is that the US government is really still scratching towards how to even engage with tribes. Consultation is a relatively new concept within the tribal federal dynamic, really only coming in like this century. And even then, right, the record has been very spotty across agencies, very spotty across administrations. There's no cause of action generally outside of a few narrow like statutes for when an agency fails or sort of comes short in engaging with consultation. But even the most robust aspirational version of consultation does not come up to what is envisioned in documents like the UN Declaration on the Rights of Indigenous People, engaging with tribes as distinct sovereigns that are entitled to free, prior, and informed consent. And so, you know, engaging in this letter is both presumptuous in that it is setting the terms of engagement. It's presumptuous in that I think it is still failing to recognize tribes as sovereign entities, but rather as groups of individual stakeholders. It's presumptuous in dictating the specific questions and terms and the assumptions underlying those terms, but it's also presumptuous in where it is postured in this history of consultation between the federal government and tribes, and where free, prior, and informed consent is evolving on the international sphere.
Well, thank you for that. And, you know, since we are in this consultation space, it certainly is, it's a bit of a challenge, right? When the objective or tribe's goal is to secure that free, prior, informed consent, but we're handed a consultation opportunity. Could I play devil's advocate here for just a second and say, you know, if tribes don't actually engage with all of the questions that are listed, is there any risk that the Patent and Trademark Office will just say tribes aren't interested, and therefore, you know, they shouldn't really consider their position when they're going back to WIPO and negotiating? Professor Carpenter, is there a risk that we might run by not really engaging here?
Well, I would love to see tribal leaders and tribal lawyers engage as fully as they can. And I realize and regret that it's such a burden, that it's coming up quickly, that there has been a 24-year history during which, you know, conversations could have evolved more substantively over time. But I am a little concerned about the risks that you pose. And the time really is now, because, you know, under the schedule, the consultations are set for January 16th and 17th. The comment state closes not long after. And then this instrument on genetic resources and associated traditional knowledge, it's going to diplomatic conference in May. May 13th. And so as much as I really embrace and share the critical viewpoint of many folks on the inadequacy and the short timeline leading up to this consultation, the pragmatic side of me really hopes that tribal leaders and lawyers will engage in this opportunity. And I guess, one perhaps point of solace is that communicating to the U.S. Patent and Trademark Office that tribes have traditional knowledge, traditional cultural expressions, genetic resources that are critical to them, that are protected as a matter of federal and international law. Even that is such an important baseline point to make, that even if there aren't comments on all whatever number of questions, I still think that getting across that critical point, maybe substantiating it with stories, with examples in the way that Erin modeled earlier, those are all really critical points of engagement that tribes could do on their own terms, sort of to underscore the title of this webinar. I think tribes can make the consultations, their contributions, their own, and still make an important difference here.
Wonderful. Thank you for that. I do have one last question, and hate to just kind of spring it on everyone, but I'll do that, and then we'll open it up. I know Preston has a question or a comment that he wanted to make. Just kind of envisioning what this could be. What would an ideal process look like for tribes to really give the USPTO input, or to really get to that point of free, prior, and informed consent on how to protect traditional knowledge, traditional cultural expressions, genetic resources? How might we reorient this in a way that would actually accomplish that? What would that process look like? What would we aim for? Professor Sosi, maybe we could start with you.
Thank you, Trevor. That's an excellent question, and it deserves so much thought. And I'm sorry for any deficiency in my response. I just want to say that out of the gate. I thought back to the Native American Graves Protection and Repatriation Act of 1990, which was the first enforceable federal statute protecting items that are of tremendous value to tribal peoples, tribal cultures, tribal religions. I mean, that statute was historic, and yet it was also deficient. It wasn't complete. We had to have many rules and many changes and many arguments with the various quote unquote stakeholders of museums. And so if you thought about the moment that we are in right now, it deserves something like that from the tribal perspective. And that's why I agree with my colleague Kristen, that even if the statement that a tribal government submits is one paragraph that says the importance of this knowledge and this discussion to them, that would be a great start. Because the other side always thinks of everything as the commons. That's the dynamic of discovery, whether it's land or whether it's intangibles. They always want a big public domain, a big vehicle for discovery, and then they enclose things. And that's what these questions represent in my mind. They're trying to say, look, we have a whole commons, but then you tell us what's enclosed. Well, maybe we want to recast that in the conversation about knowledge and about the use of knowledge and about the stewardship of knowledge, about the significance of knowledge to cultural survival over time. And then if we could get some form of, and this is just my personal opinion, we get some form of national legislation that is directed toward the category of intangible cultural heritage, then we could start looking at various tribal governments' views of that. And I believe that the Cultural Preservation Office from Hopi is on the call or was earlier. It would be very important for those folks to weigh in from those respective tribal ways of knowing, just as our colleague from Tulalip. They're not all going to look identical. There can't be a one size fits all. That was the lesson of NAGPRA. You could have the terminology, sacred object, object of cultural patrimony, but tribal law had to inform what actually fit within that category. So I see a similar process that might be at play here. Thank you.
Thank you. Professor Van Schilfgaard, do you want to jump in?
Yeah, I'm trying to dream big. It's so hard. Obviously, like the national legislation, it's a big deal, which must include annual appropriations, funding tribal delegates to actually attend the WIPO negotiations in addition to the United States diplomats. If the United States is sending anybody, that must necessarily include representatives from tribes. I think that there are 3 meetings a year at WIPO, at least, that are engaged in these negotiations. Before and after each of those meetings, there should be, whether it's a consultation, a debrief, or some other type of like formal meeting between the USPTO and tribes discussing the negotiations, clearly stating what the United States position is. And having like full transparency with tribes and an opportunity for tribes to clearly state their positions and have those positions incorporated.
Fantastic. I would definitely agree with all of those. Professor Carpenter?
Sure. Thank you. And I endorse what Professor Sosi and Professor Van Schilfgaard have said, and focusing more on the current moment and the international moment. So what's my dream sort of outcome right this minute, given the realities? I would like to see PTO as well as Interior and State realize the significance of this moment, to include, to go from this consultation to a very robust schedule of consultations toward an objective of free, prior, and informed consent leading up to the May 13th diplomatic conference, and also to use this as an opportunity to start consulting on a regular basis, because there will probably be other instruments. I think we're envisioning this one as probably the baseline instrument. Professor Sosi may disagree with me, but this could be the gateway to a traditional knowledge and a traditional cultural expressions treaties on those points. And if PTO, Interior, State could say, okay, this is the wake-up call. We need to start working with federally recognized tribes and others in a very, very serious way in these international negotiations, definitely for this baseline, this floor instrument, but certainly going forward for any additional ones. And in that work, we should be guided by tribes' own laws, customs, and traditions, the requirements of federal Indian law, and the requirements of international law, including the Declaration on the Rights of Indigenous Peoples. It's not too late, even though this should have happened much earlier. It's not too late to get very, very serious about it now. And I guess I'll just make one other point, which others have made too. This is one international process in which a U.S. agency or department is representing the interests of tribes or potentially limiting the rights and interests of tribes internationally. So in some ways, this should be a wake-up call for all of us to make sure that tribes assert a seat at the table when these international negotiations are happening. NCAI has a resolution calling on the United States to appoint a special envoy or an ambassador to better take into account, to engage in consultation and consent when negotiations like this are happening. I hope this is a wake-up call on this one. These interests are so sensitive, and it should be a wake-up call on many other international meetings like this one, where tribes and tribal interests need to be recognized and represented, and the United States needs to be accountable for all of its obligations to them. So thank you.
Oh, wonderful comments. And I hope a lot of people are listening, because I think you've laid out, you all have laid out exactly what needs to happen going forward. And I hope we can push for that. I'm going to go ahead and have Preston Hardison go ahead and voice his thoughts and comments. I know he wanted to chime in here. Preston, do you want to go ahead?
Thank you. I'll just talk briefly, and you know, I have a lot to say because I've been in this so long. I'm also happy to just in the chat post my notes and observations as I go along rather than intervene all the time. But and that might be useful to people. I just wanted to point out, I'll get to GRs when we get to GRs later, but I wanted to point out on this participation issue some of the process time and procedural barriers that we have. We have some time on the TCEs and the TK instrument. So but on the genetic resources, remember, this is going to diplomatic conference in May. There are 180 nation states in the room. In order for our proposals to get on the table, we need one country to put it at least to put it on the table. We need, but we need consensus to keep it on the table and keep it in the text. And one country can also delete our proposals. We had an example in the last negotiation where we had a very amplified preambular statement on the United Nations Declaration. It talked about respecting and recognizing the declaration. After much negotiation, it got to the last round and the United Kingdom killed it at the very end. So we still have it in the text, but it now just refers to, acknowledging the declaration. So we lost all that amplification, and that's what happens to us regularly. Again, when you look at the text, you need to understand that that its failures aren't necessarily because we didn't try or weren't aware we were. It's, you know, we lost a lot of things. And then also when you look at the text, realize we've done a lot of work in the absence of things. So there are things that used to be there. For example, in GRs, it talked a lot about the public domain. That's gone, and that's largely through the Indigenous Caucus that was working in these. But again, the reality of this very short time scale needs to be taken into account. Thank you.
Thank you, Preston. All right, we have about 5 minutes left. Panelists, did you have any other questions or points you wanted to raise before we wrap up? I know we've had a really robust chat here as well. So, you know, for folks that want to take a look at what's been happening in the Q&A, I know there've been a lot of great questions, and thank you to the panelists for chiming in on those. I think, you know, many important things going on there. Lauren, do you want to go ahead?
This is Kristen's point, but I always thought it was such a good one about thinking about the moment, right? This instrument's been in negotiations for 23 years. It took similarly decades for the UN Declaration on the Rights of Indigenous Peoples to come to fruition. But in that time, I think, right, like to the extent that broader society is influencing the production of these instruments, and then conversely, these instruments are influencing where society thinks about. I think the notion of like these companies and designers and artists and the ways in which they see Indigenous people and see Indigenous designs has shifted, and that there is a general embrace in private industry, maybe not broadly, but much bigger than it used to be, for consulting with Indigenous people, seeking out their consent, seeking out their participation in the development in a way that maybe wasn't true 20 years ago. And so like this moment and the ways in which the USPTO is now seeking out Indigenous participation, who knows why suddenly now they're doing it where they didn't do it in the last 23 years. But there's likely something about the ways in which they're getting pressure from private industry that can be leveraged and certainly uplifted, that this has become the norm more broadly speaking and is influencing this like lawmaking moment now.
Thank you for that. Let's see, Professor Carpenter, did you have some last words you wanted to share?
Well, I second Lauren's point for sure. I think whereas the protection of Indigenous peoples' cultural properties previously might have been perceived as a limitation on innovation, development, production. It's now seen as a critical and important part of it. And as long as it's occurring on a consensual, bilateral, fair and engaged way, I think there's so much excitement and potential. So this is a good moment for a paradigm shift, particularly as Professor Sosi often reminds us. This is, that we're suffering from climate change. We need societally the wisdom of Indigenous peoples, not that they have an obligation to provide it, but if they're willing to on their own terms, they have incredible knowledge that can assist the world and can be brought to bear through negotiated agreement and development of all sorts of products in the sciences and otherwise, which are particularly at issue in the genetic resources realm. On a slightly more specific note, there's a wonderful new draft article by Peter Yu reviewing the genetic resources instrument. And I'm going to try to drop that in the chat as well. He's a wonderful intellectual property lawyer who is on the call and has been very helpful in our work on this. So thank you, and thank you everybody for being on this one.
Wonderful. And then Professor Sosi, I'd like to give you the last word, if that's all right.
Thank you. It has been such an honor to be with Professor Carpenter and Professor Van Schilfgaard, and you, Trevor. You all just fill me with pride, and I love the positive tone of this very last comment. So I will join that positive tone, even though I'm a consistent worrywart, and with genetic databases and what you can do with that, I'm always a little bit suspicious. But I'm going to go into the positive and say that, in line with what Kristen just said, if you viewed that relationship of Indigenous people and land inclusively of the knowledge that's associated, and I think the First Nations people in Canada at many conferences have actually said that explicitly in so many amazing ways, and in Australia. So that's really the ethic and that is pivotal to survival. So this knowledge is pivotal to human survival. That is the promise. But again, the exploitive aspects really cannot be replicated. And if you look at what's happening with water, and you see that old 1922 compact and the way that Mexico was left out initially, and now we have to rework Indigenous people's interests in the water with Mexico and a climate change environment, that is what we're dealing with right now. It's scarcity, and yet there's an abundance of knowledge and creative solutions from the Indigenous peoples who've always had that relationship with the land. So that's the promise, and that's where I think we're headed with this discussion. Thank you so much.
All right, thank you very much, panelists. I know there are a few more questions in the chat, and we'll certainly work on those as we go along. Right now, we're going to transition to an actual kind of engagement session. We're going to be talking about brainstorming on these issues, and I think our panelists and the presentation just before us set this up really well, and so we'll have plenty to talk about. So we're going to transition now into that. I'm going to have Makalika go ahead and join us again, and what we'd like to do is we'll have kind of an initial response by Makalika, who's going to tell us a little bit about how the National Native American Bar Association is approaching the comment process. And then we'd love to hear from any of you in the audience who'd like to make comments or would like to engage. Again, go ahead and raise your hand, and we'll go ahead and call on you in order, and we'll turn your microphone on. You may have to go ahead and click on your microphone on your end as well. But we're looking forward to having a conversation here. Of course, all of our panelists are invited to chime in. We've been very grateful for all of the contributions so far from those of you that have raised your hand that have wanted to make comments. So thank you very much. So I'm going to go ahead and turn the time over to Makalika to go ahead and talk about how the National Native American Bar Association is approaching all of this, what kinds of ideas they've had, what they're doing to respond to the comment and the consultation. So I'll go ahead and hand it over to you, Makalika.
Sure. Thanks, everyone. So like I mentioned earlier in response to part of the Q&A, I think it's really important that stakeholders from across Indian country and Native peoples in the United States participate in this. And that said, the way you participate is probably and should be really diverse in terms of the nature of your comments. And so the organizations that are intertribal or associations like the National Native American Bar Association that really attempts to be a common denominator voice for Native peoples. You know, what we say and what that looks like might be really different than what someone who is trying to advance the needs of a very specific tribal community group or even indigenous practice within a tribal community. So I know that in the Native Hawaiian community, you know, what our customs and traditions require for the protection of knowledge varies widely by what the practice is and also what the lineage of that practice is, right? So you would expect, actually, even if you were to look at maybe a very zoomed in example of just what we need in the law to protect the culture and practice of hula, you would expect to see really different points of feedback. There should be something harmonizing about what you see across those practitioners, but it would be different. So one of the things that I think we want to invite in this session is hopefully a safe space for people to ask questions about what that diversity could look like, and really encourage you to participate in the way that is right for you and what you need and the community and practice and concerns that you want to represent. So that's all to say that I don't think everyone should be saying exactly what Nab is saying. But what NABA is going to try to do is put forward comments that we're uniquely positioned to share that are sort of common denominator in nature and reinforcing what the legal issues are. And it doesn't all have to be squarely about the practice of law or the challenges that we see in our perspective as lawyers. So that's another reason why I'm happy to share what we're doing, but that doesn't mean that everyone should be doing what we're doing. So what we will probably do is have 4 different parts to our comments. And so if you look at the PTO's invitation for comments and also the related consultation, tribal consultation, which, you know, they're running 2 different things, which I think has been mentioned already on this call. There's webinars this month, and then the written comments, if you'd like to provide them, would be due from tribal stakeholders on February 23rd. So we'll submit by that deadline. And we're probably going to start by talking about what tribal consultation obligations are. We'll talk about what the U.S. government's obligations are, both with regard to its federal trust duties to Native people. But we're also going to talk about, oh, sorry, Forrest, I think that you're sharing your screen. I can see your Outlook. Okay, there you go. We'll talk about what the duties are under UNDRIP and other international instruments. So we'll start by just reinforcing what the law and international illegal instruments and federal policy currently says about how the PTO should even be engaged in this process. And a big theme from that is, you know, this is not enough. So we'll start there. We will then talk about the questions that they've asked. If you dig into the questions, I believe it's 19 questions. And like I'd mentioned in my Q&A earlier, I think in part they're getting at how should we think about negotiations at WIPO right now, but they're also getting at how will we eventually implement something that we were to agree to, right? So that makes sense that if you are participating, you know, you can't be participating in good faith at the WIPO level if you're not looking ahead to how you would then implement whatever is developed and you sign on to in your national law. So when I look at these questions, I see them at different altitudes and they give different opportunities to comment. So what NAB is going to try to do is look for opportunities to ask for things that we see as thematic for Native peoples. And then we're also going to use the small but mighty bench of IP practitioners that we have in our IP committee to talk about the things that we think could be done, whether it's in the practice of the PTO or the US Copyright Office, which is another federal agency that's a big player in the IP system, to advanced tribal needs and Native peoples needs, and try to be concrete where we can. But at the same time, again, trying as much as we can to actually keep it at the altitude that we believe is helpful for all Native people. And then there's, we'll put together a call to action. So when we submit these, one of the things that we're told will happen but might not be immediate is as people submit their comments, they are supposed to eventually be made available for people to look at. I'm actually query if they don't do that, whether you could just make a FOIA request for them. But they're not going to be immediate. So for people who are used to practicing with the PTO, there's usually a pretty short delay when you're in the practice of prosecuting trademarks or patents. When you make filings, they get posted within, a few days. And so you're able to see stuff. In this comment process, that's different process. And so people on this call have heard different things from different people about what's going to happen with those comments. Novel will post ours. So I can't promise that they're going to come out much in advance of the deadline. We will do our best because if it helps people to see what we've written, I would love to have that be available. But because we're an unstaffed and volunteer organization, it might be coming in pretty hot. So anybody who would like to see a working draft within our Native communities, we do want to be a resource to you. So let me know. It won't be hard to get a hold of me, so Trevor can maybe put my email in the slides that get posted on the on-demand later. We want to help people if we can be helpful. But I would also monitor and see how the PTO is posting what other people submit. I think whether they're allies to Native peoples or part of the Native community or not, actually the perspective of others on all sides is going to be helpful to watch. And if we are able to get access to the comments from the public that are supposed to be submitted by the end of January, we will use that to inform our comments in February as well. But as I said, a little hard to predict because we're hearing different things about how the PTO will allow those to be accessed and how fast that will occur. So that's a high level of what NABA has planned, and I'm happy to take questions, or I think as Trevor said, we want to moderate a discussion where others who are willing to share or ask questions can do that.
Thank you so much, Makalika. Yeah, so we'll go ahead and if folks want to participate, want to chime in, go ahead and raise your hands. I'm going to go ahead and send out the links to the consultation and also the comment requests in the chat real quick here. All right, I think I got those right. Hopefully. All right, so maybe just to kind of start off, Makalika, so we have two different modes of engaging, right? One is a public comment, one is a consultation webinar. Are there different approaches that you would recommend, or maybe not recommend, but are there different approaches that NABA is taking to engaging in those different modalities?
We haven't made a final decision on whether we'll submit other than written comments. I think for us, the written comments, that's our preferred way of doing it because it's probably going to be pretty lengthy and nuanced. And so I just think our organization, it's a comfortable way to do it. Also, if you're participating as an organization, written is helpful because organizations usually mean that you had to get it vetted and approved. And so you could do that through written statements. But for us, I think it's that combination of the heft of comments we aspire to submit and the way that we would need to get that approved by our board and sort of vetted by our stakeholders. Written is going to be the easiest way to do that. But one, for individuals, it might not be the easiest way. I know if I'm talking to an audience of Hawaiian cultural practitioners, I definitely don't want people to feel like written is required. So I think people should participate. The different modes of participation are there for a reason, and use the one that's comfortable to you. I think what's important is that we come out in force. To show, even if we come out in force, just to say not good enough, do more, spend more, give more time. And even if you say that, I think that's powerful.
Okay. Again, so if folks want to go ahead and chime in here, now that we've had the chance to think about the WIPO negotiations, talk about the USPTO's obligations to tribal nations. Now we're jumping into strategy, and we'd love to hear your thoughts on how you plan to approach the USPTO. Are you planning on attending the consultations? Are you planning on providing comments? What would be some thoughts that you have on engaging with this process? Have any of the comments by our panelists resonated with you? We'd love to hear your thoughts and feedback. I know we have a few folks that have posted in the chat, so I'm happy to jump in there too. But if you're interested in chiming in here, we'd love to hear from you. Go ahead and press the raise hand button, and I'll go ahead and call on you, and you'll be able to unmute your mic and share your thoughts.
I wish we had a poll feature, because I'm kind of wondering, Trevor, based on the 57 people that are dialed in today, which is a great turnout, by the way. So thank you to everybody. I'd just be interested if people are willing to just chime in on, where are you in your thinking about this? Did you join this call because you expect to participate? And if so, are you planning to participate as an individual? Are you doing it on behalf of tribal government? Are you doing it on behalf of some other organization? Or did you come on the call not sure and you're here to gather facts? I think it'd just be great to hear from some group of this 57. Like, what's your thinking about this?
And I'll try to create a poll. Actually, I think I might be able to do that. So bear with me just a second. But if anybody wants to jump in here, Marcos, I'll go ahead and turn your mic on here. There you go.
Hey, thank you very much. Thank you very much. It's been a brilliant panel. I think also really inspiring to hear this kind of detailed and insightful legal analysis. I'm an educator, but I'm also have served as a delegate for Mexican indigenous peoples living in the United States to the constitutional reform that took place beginning in 2019. Those constitutional reforms on indigenous peoples followed closely the advances of the UN Declaration on the Rights of Indigenous Peoples, and I've been a delegate from our community, the UN, as well, in the UN Permanent Forum. And so that, unfortunately, those constitutional reforms are stuck in the Mexican Congress and haven't been advanced there since the pandemic, but we completed our job there. I'm really intrigued in trying to understand the transnational context, especially with Mexico, because there's a different legal pattern with Canada, between indigenous peoples in Canada and the United States than there is with Mexico. Much less legal precedent and certainly no J treaty, to mention one example. But I think that in this case, I have a lot of questions swirling around how to follow up on this with regards to education for young people, things like the Smithsonian Institution's Native Knowledge 360 and how that intersects with indigenous intellectual property, and even these more epistemic and ontological concepts that I also hear you all addressing with regards to terms like property and even a basic concept like self-determination. And so, I mean, one frustrating thing I'd be interested in hearing comments on is a lot of what we've been celebrating lately in terms of that intersects with indigenous intellectual property comes in mass media. So, for example, a cartoon, is released by Marvel, and it tells, something that's very obviously tied to creation stories or to origin stories. a movie highlights a particular historical tragedy and is celebrated in a context that makes that public, and that process of free, prior, and informed consent and its intersection with everybody else's stories in that context is not public. You know, how does that happen, as an example, and was that effective, or did it advance these questions in any way? And so I wonder how much indigenous creativity and futurity is tied to the profit-driven motives of Hollywood or other mainstream media, as an interesting conflict or self-contradiction that we're navigating. You know, some African Americans talk about strategic, I guess, opportunities, and so here locally, we're also I'm also an advisor to the Gabrielino Shoshone Nation, and here locally, I think the questions about the rights of non-federally recognized tribes, given that those rights don't derive from the federal government or its recognition process, but are contested, you know, even by other tribes. So those are questions that we're navigating here. Thank you very much.
Thank you for that comment. Yeah, absolutely. It sounds like there are folks taking lots of different approaches to this. And actually, one of the questions that was raised by Mary Kate Holbada is she asked, how might the written comments due on January 22nd per the negotiation notice differ in substance from the comments due on February 23rd for the consultation notice? Makalika, do you want to chime in on that? I mean, is there a substantive difference? Is it merely just kind of the timing, the audience? How should people be thinking about this?
Audience for sure is going to be different. So that's probably going to be, I think, the biggest differentiator is that the audience in January is going to be the audience of people who are predominantly not Native, not coming from the perspective of Native traditional knowledge and cultural property stewardship. That's why it's important to me, and I think, you know, anyone else who's doing this, trying to get those comments from the PTO and trying to get them before the February due date. So I think the latest is that they are going to post them, but the question is, are you going to post them fast enough for us to, you know, get them and incorporate them into what we want to say? Substantively, though, I mean, you could absolutely submit your comments by January. The way that they're approaching it, though, you know, all the things that they're supposed to do in federal tribal consultation, all the things, the best practices and duties that the federal government has, that's what's supposed to apply to the process that's culminating with written comments due in February, at the end of February. Whereas January is just their more general administrative duty to take public comments before they, you know, take certain actions.
Okay.
So yeah, you could say the same thing substantively. We just know that there's going to be largely two different groups that respond to different ones. And technically speaking, what the federal government is supposed to do for tribal consultations is not the same thing as a normal administrative process to get public comments through some sort of rulemaking process. So technically there's some differences on what they're supposed to do. And, you know, who's invited is more narrow in February. But as a tribal advocate, if you want to get your comments in by January 22nd, you could. I just would make sure that you say like, hey, I'm a tribal organization, and try to trigger having your comments treated as such as a part of that tribal consultation versus a member of the general public, because, you know, they are supposed to have higher duties, trust duties and other things related to their work to consult with tribes. So tribal allies can submit in January 22nd. Tribal people can submit in January 22nd if you want. But you know, they're supposed to be taking it. There's different sensibilities that apply in tribal consultation, and so might as well just give yourself the extra month anyway. I'm relieved to see that we're getting the more time. Could have been the other way, I suppose. So that's nice.
All right. So we're gonna, go ahead, Sue.
Yeah, just to jump in on that, one thing that happened is that the USPTO, was telling us back in 2022 that they were going to be having the tribal consultation, right? Remember that webinar that they did in June of 2022 to help prepare for the consultation. And then my understanding, from what I've heard, is that it got delayed a bit because of the desire to also do this public comment process. And so I guess one thing to think about is to what extent the USPTO is thinking about the balancing of interests, because that is something that comes up a lot in the negotiations, that stakeholder interests must be balanced. And so I guess I have some concern that if on the public side, there's not pro-tribal input, then, that's going to be balanced by USPTO. Of course, the larger point is that they shouldn't be doing that kind of balancing for all the reasons that have been stated, but just to give that sort of context there.
Fantastic, thank you. So I think we almost have our poll ready. What we're going to do is we're going to just ask generally if folks plan to submit a comment or participate in consultation. Again, you don't have to participate if you don't want to, but we'd love to get kind of just a straw poll to see who might be willing to participate or who is planning on participating. I know some folks have felt like the webinars and the materials provided by the USPTO have been helpful. Is it Tada Atom who posted on the Q&A that said that the USPTO's webinar was helpful, yet apparent how much people at the USPTO do not really know much about Indians or these issues. Some do, but the majority don't. So
yeah, I always think that's funny, to be quite frank. And I mean, I know this is open, so this is not really an in the family conversation, but I'll pretend it is. I think the USPTO it fascinates me because the way I experienced their interaction with tribal communities and tribal people is, let me come educate you. But really, this comment period could be a great opportunity for us to educate them as to all the problems. So I often see, it's like we just need to convince Native people. Native people just don't understand trademarks. They don't understand copyrights. They don't understand patents. So we just need to go out and teach them what IP is, and bring them to this water so they can drink it because it's so tasty. But really, what I experience when I'm having conversations with Native people who are actual cultural practitioners and knowledge stewards is that they know enough about it to know they don't want it. And so, one of the things that people can do, if you have sophistication in this area, and I challenge my colleagues at the Native Bar to submit really actionable, legally grounded recommendations to the PTO, because we definitely, I think feel as lawyers in this work, a duty to bring back as concrete of progress for our people as we can. That's why we all went to law school and are doing this work. And I think that someone's going to have to do that if you're going to get the US government to move in the right direction. Someone's going to have like really specific ideas as to what they can do that would be politically palatable to get, incremental progress. But I also feel like, as I look at my own community, not everyone is practicing. Most people aren't, right? There's a very small percentage of us who are practicing and are going to have like really specific recommendations. I think it's helpful to just tell them everything that's broken for what it's worth. So for people who are not doing this necessarily as lawyers or as IP lawyers, I think it's also very helpful if they get 2,000 submissions that give them story after story after story of some problem that they are just largely ignoring. And one of the things that I notice sometimes in the writings about this work is that there's a struggle to articulate what the actual problems are. And then when we lift up a solution, it's usually lifting up a solution to that very specific problem that kind of caught their radar. So it's like, oh, we set up this program, and I'm gonna now pan out and not just keep beating up the US. I'll just talk like, globally. If you go look at stories that get posted even at the WIPO level, it'll be like, India did this great thing to help this really specific community of weavers And it's like that's great, by the way. I'd ask them and I defer to them on whether that's great. But it's not nothing. But it shows me that they're trying to be really pinpointed about even, I mean, if you look at even our own law, right? Like, so it's not as if America doesn't have some laws already in place that attempt to make progress on this. The Indian Arts and Craft Act is an example. I would say it's, like a small pebble of progress and what needs to be like just a big mountain of work done. And it's very meaningful, and yet, there's so much yet to be done. And so that's what they'll tend to do is they'll say, okay, give me your list of problems. And that's one way that we do it is we chip away at it with like individual changes to rules or individual pieces of legislation. So, they're trying to get a holistic position that will help them to agree to something really big in terms of a genetic resources international instrument. But just use it as an opportunity to tell them what you need to tell them about all these issues. So if your thing is language, do it. Talk about language. Are they focused on that right now? Not really, but honestly, it's really hard for you to move something in this space without it impacting all the other kinds of IP and cultural property. It's really hard to develop norms around what you're going to do with genetic resources that aren't going to affect the norms on how you handle all the other pieces of cultural property. So I'd also tell people, like, don't be intimidated. Even if you just send them comments that say, these are the 5 things that are broken in my community and are like really causing harm. Good, tell them.
All right, thank you, Makalika. I have Preston Hardison with his hand raised, so I'm going to go ahead and unmute you there.
Okay, thank you. And yeah, I was going to make a couple of comments. Well, first of all, remember we're in text-based. I agree. We need to be as amplified and bring up as many issues as we need in the consultations with the United States. We need to keep an eye on future work here in the United States, regardless of what happens at WIPO, because WIPO is just going to be a framework instrument. It will have to be implemented within the different states. And so regardless of what kind of instrument we get, a declaration or a treaty or whatever, we're going to have a lot of work to do in the United States. So, you need to give them the full meal deal of all your issues. But then there's also the issues of these instruments that are on the table. And the most critical, again, genetic resources is going to diplomatic. At diplomatic, we will have very narrow opportunities for change. Of course, everything is, nothing is agreed until all is agreed. But in reality, we're in the late stages and final stages of the GR negotiations. We have play in TK, we have play in TCEs. The 2 issues that I think would be good to be in many of the submissions, but again, I'm not binding anybody's hands. This balance of rights issue, this is core to the way the USPTO addresses things because they view everybody as a stakeholder. And so most of their submissions in the history of WIPO have been on behalf of industry, on behalf of their culture industries. What they really want is the ability to use Maori tattoos in any movie they want and make money off of that, et cetera, et cetera, et cetera. And they really do believe that publishers have a right and researchers have a right to access your knowledge, your traditional culture expressions. So that really needs to be hammered, that you don't balance tribal rights. And again, this relates to the public domain versus inherent sovereign rights versus non-derogable human rights and other non-derogable rights. So, working these themes into it, reminding them that domestically they have illegal dominion over traditional knowledge in my mind, because again, as we pointed out, there is no implementing legislation that passes tribal inherent rights to govern their knowledge and expressions to the PTO. It was never expressly grabbed by Congress. So anyway, the balance of rights, the public domain issue, and also remember in negotiating, putting in all these issues is great, but at the end of the day, you also want to have a section that boils down things to the negotiating issues you want them to hammer and to support you on. And those can't be the whole meal deal. They have to be, very targeted in order to, get through these text-based negotiations. Thank you.
Thank you, Preston. I saw that we have another comment in the chat here. It says, what are the solutions we should be suggesting regarding the public domain and the USPTO's position that fundamental knowledge and history is in the public domain? So I think that, we've heard a little bit about this already in the roundtable and in the panel earlier. This is a challenging topic, right? And not many of our indigenous societies have necessarily a concept of the public domain. And so even just answering that question and opining on, how that should work might be a little dangerous. At the same time, clearly the USPTO has an interest in dealing with the public domain. They want to, as Professor Sosi said, they want a really large, robust public domain. How should Indigenous peoples approach this issue, this topic, this question? What are some of the different positions they might take? Makalika, do you have any thoughts on that?
So in the public domain, what you're basically saying is, oh, sorry, am I on mute? Oh, no, I'm okay.
I just
Yeah. So what's the relevance of the public domain? So if something's in the public domain, what you're saying is that everybody can use it, right? Everybody can use it, and it is not ownable as an asset. And so I know that other panelists have talked on this webinar about wanting to take public domain out of the discussion or out of this instrument. So I think, if anybody who talked on that wants to come off mute, and I think Aaron, you were one of the people who talked about it for Tulalip, maybe reinforcing that. But I think it is going to be really challenging because you're basically, here's what's hard, and this is not unusual in Native advocacy, right? Which is that Natives are saying, we never gave this to you. And so you need to put law in place that recognizes we never gave fill in the blank to you. And on the other side, you've got a government and all these private stakeholders who think that they've been getting it for free the whole time. So they think it's a carve back. Or a clawback. So that becomes like the problem, is that you've got people who are like, well, I never gave it to you. It's like, well, whether you gave it to me or not, I've been treating it as if it was open. And so any change at this point, as a practical matter, is a clawback of something that I've been getting for free for quite some time. So, whether or not the public domain is something that you want to address in these comments, maybe you don't want to, and I would defer to Aaron to talk a little bit more about what his suggestions are on that front, but it is going to be a massive issue in what progress looks like over the next 50 years.
All right. Aaron, do you want to go ahead and chime in on that?
Sure. Yeah, no, I was eyeing that question when it came in. So for our comments at the Tulalip tribes, just based on reading the room at the negotiations at WIPO-IGC, the only member states advocating for public domain to be in the WIPO-IGC 3 instruments generally is the U.S., the U.S., South Korea, and Japan. And UK has been a late addition to that trio. So it's about 4 people or 4 member states that are really advocating for public domain to be introduced into the instruments. I mean, I think it's really simple, and this is going to be Tulalip's approach, is just telling the USPTO in this consultation that we don't think public domain should be included in these international instruments. There are major regions such as the African group and the Asia Pacific group that haven't aligned with having public domain included into these 3 instruments. And even with GRULAC, that represents the major group for Central and South America and the Caribbean, also are against public domain being included into these 3 instruments. So just from helping get the the treaty, moving forward in this process, it would be very helpful to have the US not take a position on including public domain, because I don't think we're getting away from public domain as a general principle in the US in our own domestic context, and with our bridge systems to other Western countries. But when it comes to traditional knowledge or TCEs or knowledge associated with genetic resources, it doesn't seem applicable unless that's specifically or explicitly gifted to society from a tribe or from indigenous peoples. So that would be Tulalip's approach with it, and stating in our written comments or in our verbal testimony, just not including it in these treaties.
Thanks, Aaron. Sue, Noe, I know you had a couple of thoughts on this. You want to go ahead and chime in and share your thoughts on the way that you've approached this there at NARF?
Sure, Trevor, thanks. And thanks to Aaron. And really, I'm basically saying the same thing that Aaron's saying, because our positions have been in alignment. And in the past, the Indigenous Caucus had made a statement about this. And what we said there was that references to public domain in the instrument should be removed. And the rationale for that is that the purpose of these negotiations is to create protections for Indigenous peoples, TK and TCEs, that historically have not received protection within in the intellectual property system. Indigenous peoples, unless they have actively or affirmatively done so, they haven't authorized their TK and TCEs to be put into the public domain, and doing so would be then inconsistent with their own laws that govern their TK and TCEs. So to focus on the protection of the public domain, as I said earlier, would be to legitimize hundreds of years of theft of Indigenous peoples, TK and TCEs. And that's clearly not the intent of these negotiations, nor consistent with the mandate of the IGC, which is to work on international legal instruments for the protection of TK and TCEs and GRs and associated TK.
Absolutely. Thank you. Thank you for sharing that, Sue.
Yeah, normally when you think about public domain in the US, so I 100% support all the things that were just said. So then to me, it's more of a focus. If you can get through that, which hopefully we do, you still have to contend with it nationally, right? So when you come back and you're trying to get things done that are implementing, or by the way, of course, the US can take action to improve the law in the United States without an international instrument, right? I don't want to take us way off the path of the focus of this conversation, which is how to equip everybody here to participate well, the way that you want to participate in this consultation process. But if you're doing it ultimately because you want to see improvements in US law, you actually don't need this instrument. We just know that this instrument will be helpful. It'll be helpful if it comes together in the right way. But of course, the US can just do the right thing, right? It doesn't have to actually. So whether you're thinking about it as, eventual legal updates that happen through implementation of an international instrument, or just, the US taking the initiative because there's the right political will to do so, you can get new acts of Congress, you can get agencies like the PTO and the Copyright Office to make changes to their rules. You can get progress whether there's an instrument or not. And so the public domain is going to come up. And one of the things, as we work with the PTO and these other agencies, when you think about public domain, I worry about it coming in as a distraction, really. And maybe that's part of what Aaron and Sue are thinking too with this, is that it's an unnecessary distraction in the context of this. And it's, trying to call, what I would forecast is that if there is successful effort over time to create sui generis protection in the United States. So say, okay, great, you have copyright, you have patent, you have trademark. One of the ways in which public domain understanding it is helpful is if you're trying to claim that someone's infringing or claiming an asset that they can't because it's either in the public domain, or if you're saying, no, actually, it's a thing that it can cut both ways. Sometimes actually for a tribal organization or a tribal interest, you actually, because of the way the law is set up, there are situations where it actually might benefit you to say that something should not be ownable, right? Because if something's in the public domain, what it means is you can't go and own it and monopolize it. And sometimes we want to be monopolizing, but sometimes there's another party trying to monopolize. We want to say you can't, right? And so that's why there's a lot of discussion around sui generis protection, because that's a trap we don't want to be in. We don't want to be in a position where we're saying, well, because a private party wants to own it, we now want to call it public domain so they can't. No, what we want to say is it's actually owned, but it's some other kind of protection that isn't a patent, a trademark, or a copyright. So we want sui generis protection. So one of the impacts of having, public domain defined, even if it's like sort of cast as, really focused on genetic resources or something like this, is that it's going to set the public domain in a way that would frustrate sui generis protection work in the future. So public domain is gnarly. I think it makes sense to try, for lots of reasons that have been shared, to not let that frustrate the process happening right now at WIPO, and at the same time for us all to be thinking about what is the answer to that and what's the implications of the public domain conversation. Because when you start implementing law in the United States, which is ultimately the goal, it's going to keep coming up.
Maybe another question to ask at this stage of the game too is, we've talked a lot about the consultation process and, ways to improve it and what we'd like to see. I mean, do you have any strategies for making those kinds of suggestions within the scope of this kind of set of comments and questions, right? If tribal leaders really would like to have a more, free and prior and informed consent type of a process, and they have proposals for how this should look, how would they frame their comments, or how would they address folks during the consultations to make sure that that happens? What kinds of posturing should they do to be able to accomplish that?
Horace, I don't know if you're directing that at me, could you say it one more time?
Yeah, of course. Yeah, so I mean, some folks might kind of take this list of questions that they've been given and wonder, how, if I really want more of a consent type of a process, like a free, prior, informed consent process, and I'm just given this list of questions, how do I go about proposing like a different way of consulting? Or how do I say, hey, I'd like to be able to have a more robust conversation on the things that matter to me, or on having my laws enforced at the federal level, or how could they move things along in the direction that tribes want? How do they get the process that they would like to be able to have input on this?
I think so typically, the folks that I see in representing Native communities in this work have a lot of experience doing it in other topical areas. So it's rare that actually I'm probably the rarity in that I'm the opposite. I've done a ton of work with the PTO and the Copyright Office and international IPOs, and don't have a lot of experience looking at other topical areas where there would be tribal consultation requirements, right? So that's like, I made a career change a couple years ago, and now my practice is broader and indigenous focused, but before that, no. So, in some ways that's helpful, in some ways it's hurtful, right? Because something that I've spoken out about a lot, and I don't know if we've touched on it yet here, is that Native peoples are, we're egregiously underrepresented in the intellectual property bar, right? This is a community of lawyers and policy people that number in the tens of thousands in the United States. And to my knowledge, we've got, maybe 20 people who identify as Native and, have dedicated their work to this domain, this subject matter expertise, right? And so from that regard, you got this really, really old, complicated system where there's been a lot of efforts to harmonize it globally. And so there's hundreds of thousands of people with IPOs in, virtually every country, working to create a system and negotiating all kinds of little bits of it. And then we've got, maybe 20 people, and most of those people actually, like, I think on that list of 20, very few of those people are actually practicing before the IPOs. So I don't say that in the spirit of, I do not want to create negative energy for the community around this. But it is formidable challenge to get this work done because we're just actually understaffed. Like, we need capacity. So one of the things that actually I think is really fair to put pressure on federal government to do is say, thanks for the tribal consultation. You guys, yeah, we should be talking about laws and things like that, but we should also be talking about just how are you resourcing this work? And how are, by virtue of you resourcing this with some center within the PTO or the Copyright Office or somewhere, like, you need to start creating jobs that put more energy on this on the government so that you can do this well, because you basically don't have anyone. To my knowledge, there's one person who is viewed as the liaison for Indigenous policy within the whole federal government on IP. So anybody on the panel or on the call who, can correct me if I'm wrong, please don't hesitate. But, we're talking about like one whole job is dedicated to this in the entire federal government. So right away, they're not going to be giving us very community specific consultation, right? So they're under resourcing the whole thing. If they actually resource this, not only would it allow them to fulfill their obligations better, it would empower them to better steward what is truly a part of the United States national treasure, right? So that's one of the things too, is that because of our history of conflict, where it's only been in recent years, and it depends on who you're talking to, that there's enlightenment in any level of government about the fact that Native people are an enriching part of this country. And so stewarding our cultural resources is a part of what makes America great. And figuring out how to do that with the experts around how that is done, which is us, is how you do it. That historical conflict and adversarial position actually is getting in our way. When you look at other countries, cultural integrity law is not crazy or new. And lots of countries most countries around the world are doing it. I mean, if you look at the history of South Korea, last recession that left their people literally hungry resulted in them coming up with a 5-point intellectual property plan for how they will never be hungry again. And that's why we all know who K-pop stars are. We all watch K-dramas on Netflix. We all want the face masks from Korea, is because they literally came up together as a people and said, how are we going to create an economy of intellectual property? And they've been wildly successful. Right. So thinking about like the problem is in the United States, we have done something similar, except instead of us coming together as a people and doing it in a way where we see each other as, a people, it's this, where Native people are just getting extracted, right? So there's this lack of mutual benefit. So one of the things that you can tell them is, you might not have the solution to how you fix this problem. I don't think any one person does, but you can tell them that you need to create some jobs where you build capacity and know-how and intelligence around how to do this, so that it's not just one person in the entire federal government running this, because you can't have what any of us would call true tribal consultation when you've resourced it like this.
Right. And I'll just add on to that and say that, well, you have the PTO that has one tribal liaison. I don't believe we have any liaisons to the Copyright Office.
No, I'm saying one, to my knowledge, one for the entire federal government.
Right. Well, yeah, definitely. We appreciate all those comments, Makalika. Thank you for kind of putting things in perspective there. Preston wanted to add that in the WIPO context, this is quoting from Preston, the public domain is a national issue. There's no international public domain. The U.S. has been trying to create public domain in traditional cultural expressions and traditional knowledge, while it does not exist for other forms of IP, except when it expires, right? Thank you, Preston, for that comment. I think, maybe another question to ask here too would be, so we have these opportunities. We know there's a diplomatic conference coming on the genetic resources and traditional knowledge piece of this. What about the other pieces? I mean, we know that there could be some movement on the traditional cultural expressions and the traditional knowledge draft instruments. Those are being discussed, but it's hard to know when they're going to be mobilized. Does NABA have any thoughts or positions or approach to those particular instruments? Are they different from the GR and TK instruments in terms of their priority or what needs to happen? Should tribes be also kind of pushing those forward and asking the USPTO to want to make those move those to diplomatic conference? I don't know. Do you have any thoughts on that at this point?
Yeah, the intellectual property system, it's funny. There are specific nuances for types of technology or content. So it's not impossible. I mean, it's currently true that there are some departure from general rules for specific needs depending on the nature of the content, right? So when you talk about like genetic resources or pharmaceuticals or for example, shifting gears, like things that might like weapons, things that might have, provide a military advantage. Like there's some rules in the Patent Act in the patent system about how that will get treated in the prosecution of patents. So when you think about the way that these things are getting dissected, uh, you know, that mirrors the ability that we have in law to create content or topic specific nuances from general IP rules. I think part of what it gets to me to be like the biggest problem to me is a capacity issue though, because when you look at how they get dissected, they are all going to influence the general rules, right? So that's like part of that public domain conversation. It's like you're not going to have a public domain conversation that's just about genetic resources. Like how you develop the understanding of public domain, even though you might be in this it might be cast as a conversation that's really focused on genetic resources, which is largely about patents. It's going to affect every conversation about all the IP in public domain. So I think we have to be thoughtful about that. I think the way that you do thoughtful work on this is that you build capacity so that you are not ad hoc in the way that you engage. I know that the reality for us in tribal communities is that we're developing, like we're on a developing stage on capacity. So I think Angela's work talking about and studying all the great work that's happening in tribal communities nationally to build our capacity on this is a good thing, but we've got, a ways to go. So do we have a big strategy at NABA? Frankly, no. I mean, NABA's 50 years old and has no staff. We're the only national bar that is in that position. And so you depend upon, just members being steadfast volunteers year over year. And so I hope that we are able over time to build that kind of stability and show up across. And I mentioned that I know that's not really like helpful for people who want to just take an answer substantively and run. But I mean, I'm being honest, like I think that's actually the biggest issue we have is that like we're trying to have substantive answers without roles for people to develop those answers. So if I had a magic wand, I think you got to deal with this today, right? This is due this month and next month, depending on which deadline you're trying to meet. So you need to get the work done. But part of our strategy as a people and as tribal nations has got to be figuring out like, where's going to be the center for IP? Where is the first native center for IP going to be? Because it currently doesn't exist. And so the people who are working on it, I mean, I think the experts in the country are on this call right now. But there's no center for IP where this is happening, and there's tons of gaps. And so our ability to show up in a way that across all of these segmented conversations adds up to a good outcome for Native people is undercut by the fact that we're just scrambling sort of ad hoc.
Okay.
But that's as much a duty that the federal government needs to step up and resource as anyone, right? So it's like it's not a pointed finger at anyone. It's just like a state of affairs.
Sure. Yeah, and I mean certainly it's a moment that needs to have the infrastructure built under it so that the tribal nations can be able to take action and move a lot of these forward and be able to provide the kinds of momentum that it sounds like the USPTO is looking to draw on, right? I wanted to touch on a couple of questions in the chat just as we close here before we take our lunch break. The first is, this is Natasha John's comment, wanting to be able to distribute some draft comments. Is there a resource where tribal nations can go to for kind of materials to look at in terms of, how to write some of these comments, how to approach the consultation? Do we have any draft material that's available publicly that could be shared? Or is this pretty much every tribe should take this on and kind of think about their own approach?
So we're going to post ours. I know NCI is going to submit comments. So if somebody on the call wants to talk about where that will be. I mean, I think ideally, like I've mentioned twice already, like I think it would be great if the PTO would just post the comments as they are received. If they need to do some scrub to make sure that, they're taking care with anything that people want held confidentially, and maybe that is something that some tribal participants are going to have is they want to share some things with the PTO that they don't want posted. I mean, I think some process for, flagging things for redaction, and having ways of doing that. Okay, maybe that needs to happen. Maybe they need to also review to make sure they're not posting things that are just like, 10 pages of swear words because someone's abusing the process. So I get it that they need to review some things, but they should have some reasonable process for also getting these posted. For us, people who are leading tribal organizations like NCI, NABA, I think we should try to get them posted on our own websites as soon as we have them available so that other people can benefit from seeing them. And I think there's an open invitation by most people on this call that if you're representing a tribal community or a tribal organization and you need our help, I don't know that I'll have my comments due or much earlier than the deadline, but call me or email me and we'll do the best we can to empower you. But what would be great is if the PTO was just posting these as they go because we're all sending it to them.
Fantastic. And I know Ryan Sela has wanted to chime in here too about NCAI's plans about posting their approach.
Yes, thanks, Trevor. NCI also plans to, I guess we sort of have two things we're going to try to do. We're going to try to get out some just, potential talking points or even really just points for consideration before the webinars actually take place. So we're hoping to finalize those this week. We can circulate them to anyone who's obviously registered for this, but then also get them out through our server and on our website. And then we are also similarly hoping to have some version of draft comments that tribal nations and other organizations can look at, either take pieces of if it's useful, or to for ideas. It probably won't be our final version of those comments, but it'd be something to draw from, at least on some of these specific issues. So we can talk through some of those pieces later in the afternoon as well.
Fantastic. Well, first I want to thank Makalika for joining us. Thank you, Ryan, for joining us here too, and all the other panelists for chiming in. Really appreciate all of your comments here during our brainstorming session. Right now, we're going to go ahead and take a quick break. We're going to you're seeing my back end here. Let's see. We're going to go ahead and take our lunch break, and we'll be back here at 1:30 Mountain Time. And looking forward to our panel where we're going to take a deep dive into the genetic resources and associated traditional knowledge draft document with a wonderful panel of experts. So we'll see you at 1:30, and thanks again for a great morning. Welcome back, everybody. We'll go ahead and start in just a little bit. We have a wonderful set of panels coming up for our second half. And so we'll go ahead and get started. And for all of those panelists who are joining me on this next one, go ahead and turn your cameras on and we'll go ahead and get started. Okay. All right, welcome back, everyone. For our afternoon sessions, we're going to be taking a special look at the WIPO Genetic Resources and Traditional Knowledge Draft Instrument. We sent the text out a little bit earlier today, but to begin our discussion, we'll hear about the urgent need for a new law and policy on this front to limit biopiracy and other appropriations of Indigenous peoples' traditional knowledge and genetic resources. We'll then hear a little bit about what our current system of patent protection offers Indigenous peoples and why it's currently failing our people. And then we'll hear a bit about the proposal on the table at WIPO that would require companies and other patent applicants to disclose when they're using Indigenous peoples' genetic resources and associated traditional knowledge. And then finally, we'll learn about how this new provision plugs into the overall structure of international intellectual property. So joining me on this panel, we have some fantastic guests here. Crystal Sosi, a geneticist and bioethicist and assistant professor at the School of Life Sciences here at Arizona State University and co-founder of the Native Biodata Consortium. We have Aman Jebru, assistant professor at the University of Houston Law Center. We have Forrest Tadanipa, assistant professor of law at Mitchell Hamlin School of Law. And we have Janua Ose-Tutu, Associate Dean and Professor of Law at Florida International University. So welcome to all of you. So we have 4 different presentations today. For those of you that are panelists, just let me know when you want me to advance the slide. I'll go ahead and do that. But we're looking forward to this, and thank you all for joining us. So I'll turn the time over to Crystal.
Got a shitting at people. All right, can you push next, please? All right. So those are all of my affiliations, or not all of them, but most of them. And I'm really pleased to also be, as announced, a representative of the Native Biodata Consortium, of which I saw a few participants on the earlier sessions. And also I am a member of the Nation or Navajo Nation. Next, please. All right, so this is a great painting by my friend Jules Bodoni, talking about colonialism, particularly related to Indigenous Peoples Day and the hubbub and furor over its renaming from Columbus Day. Next. And I want to start off with this statement: we were not discovered. Next. That the doctrine of discovery through papal bulls gave European nations rights over us barbarous nations and our lands upon their discovery. And this was unfortunately upheld by the doctrine in Matt Johnson versus McIntosh, stating that this principle of discovery by conquest of our nations gave the US absolute rights over our nation's lands, waters, and resources. And this doctrine was recently used in 2005 to disenfranchise the United Nations of their land claims. So repeatedly throughout time, settlers and settler institutions have co-opted Indigenous traditional ecological knowledges and plant wisdoms, and also our human gene variations as part of their discovery. Next, please. So this is actually the ceiling of the London Natural History Museum, called the Gilded Canopy, depicting plants that fueled the British colonies. And most of this was actually, and much of the biological discipline is rooted in this colonial act of discovering natural specimens, collectivizing them in museums and biocollections for the sake of science, and accrediting those plant and medicinal knowledges to settlers away instead of the Africans and Indigenous peoples that provided that plant knowledge instead. Next. So this is where we kind of come in terms of where we are with genetic discoveries as it relates to plant knowledges. In the pre-settler colonial state, we had an estimated 30,000 edible plant species worldwide, and yet settler and settler institutions denounced our agri-systems as backwards or primitive. But that didn't stop many cash crops and medicines from resulting from our colonized lands and knowledges. Next. Then we entered the Green Revolution, this industrial phase, which reduced biodiversity, and including a 60% biodiversity loss, contributing to a third of greenhouse gases, and also really seeing power inequities concentrated by corporations. Next. And now we're in this new phase in which Indigenous knowledges are considered key to sustainability. We're looking to seeds and varietals that have been long stewarded by Indigenous peoples as deposited in global seed banks and museums to CRISPR them back in to these monoculture crops. And then also there's a concern here that a lot of these things that were taken from our peoples to begin with are now taken yet again and perhaps commercialized and patented by large corporations. Next. So this is where I call the opification of the open data era, where we keep telling ourselves that over and over, and you can insert whatever aim here, but in order to advance science or biomedicine or biological sciences, we just need more data that is freely accessible. Next, please. But in actuality, many Indigenous nations are, because of unethical research conduct involving data misappropriated from our communities, have created policies that restrict open data sharing. Next. And we have to also contend with this fact that Indigenous peoples have long protected 80% of global biodiversity, even though we are such a small segment of the population. So the next genomic discoveries are going to co-opt Indigenous knowledges and disenfranchise our people, who are often the last to benefit and least protected from IP claims. Next. So this centralizes to this point, this question. For whose benefit are we talking about? Because oftentimes in phase one, we see the collection of Indigenous genetic knowledge. And with this tenuous claim that it's going to result in community benefit, but with really no clear path outlined for how to get from phase 1 to phase 3. However, as we see time and time again, we see corporations and settler institutions profiting first from benefit to the collection of our genetic knowledges and materials and not communities. Next. So if Indigenous peoples are not benefiting from their own traditional knowledges, then who is? And if we're talking about equity, then we also have to ensure that the benefits of our data are also distributed fairly as well. Next, please. So this is an unfortunate but clear example of how this is relating to IP and discussions as it relates to patenting in the space that I occupy. So this is a headline from Science Magazine in which, if we push next, please. In which researchers actually consulted with several communities and learned about their traditional antimalarial use. And they actually took this plant back, Quadra amara, to their institute in France, isolated the compound, and then patented it without proper accreditation to their source of the knowledges. And they were granted a patent from the European Patent Agency in 2015. Next, please. However, in this article, it actually stated like other global scientists are acknowledging that this one-way extractivism needs to be remedied, and we cannot continue to perpetuate these colonial practices. They stated that the failure by researchers to obtain the prior and free consent of their performance raises ethical concerns. And in this post-colonial context, it is time for actors to respect each other. It's cute that they say that this is post-colonial, but whatever. This is also a new scenario that we are seeing now in the US, and this is a quote from Dr. Adrian Keene, who is a Cherokee, who states that the sale of native spirituality is easily $1 million industry. We see a lot of the commercialization cooptation of white sage, which is central to many of our religious and medicinal practices. Next. It wasn't until like even at the end of the 1800s where a Lakota elder was actually imprisoned for delivering health care in the form of sage to his people. Next and next. Thank you. Yeah, now in this fetishization of indigenous cultures and our plant knowledges, it's, we see the emergence of this white sage black market in which, because smudging is now part of this cultural zeitgeist of the dominant culture, people are coming onto traditional lands that have been long held by indigenous peoples and pulling sage by the root at the cover of night, sometimes in own defiance of their own colonial permits. Next, please. And as we close the story, interest, of course, and the therapeutic potential of sage and its genome is also fodder for high impact journals like Cell. Next. So when we think about indigenous knowledges, it's really interesting. When it is mediated through Western scientific or medicinal practices, it is considered the ability for one to patent it is available or to copyright it or to trademark it. Yet, for indigenous peoples who practice their own scientific and medicinal knowledge, because it's considered like a long-standing practice, no patent is usually conferred if they want to play the system in that way. So the path to rights and attributions is unequal and unilaterally benefits one of these, and again, disenfranchises indigenous peoples in the process. Next. So when we also think about IP law, a lot of these laws are written by institutions oftentimes to benefit other institutions. And universities as one entity that has really benefited from this act, which permits ownership from inventions resulting from federally funded research, and unsurprisingly have large legal teams protected that right. Corporations also have large legal teams, but it's really interesting because they can benefit from open data and freely accessible data systems, but then also have that corporate veil of privacy as well. So really showing that this the pathway to innovation is really unidirectional for them. But for indigenous peoples, and the way that this slide is meant to be read is from left to right, with indigenous peoples unfortunately squished rightmost, is that their existence, first of all, may not not be recognized legally by a colonial government, that concepts of ownership are already many times incongruent with indigenous notions of stewardship, kinship, and relationality. And for us, novelty is really hard for us to prove in this system when it's part of our longstanding wisdom, and also unsurprisingly requires a large legal capacity. Next. This centralizes on a notion, indigenous genomic data sovereignty, which is the right of indigenous nations and peoples to exercise authority, agency, and autonomy to particular interests related to genomic data. And I want to remind that the sovereignty is intrinsically defined and not colonially defined. Next. We also have to contend that the Nagoya Protocol, which is a legal framework under CBD, formalizes fair and equitable sharing of benefits arising from biological diversity. And it also encompasses biological samples and associated indigenous knowledges, requiring equitable return of benefits to those providing samples. However, if you notice in the map behind it, you can notice that the US has not signed on to CBD. So this has a lot of questions. Like, this is great blanket language, but how can indigenous peoples actually operationalize the Nagoya Protocol? Next. This is a huge question and concern because we have now global sequencing superpowers that are arising to collectivize genetically derived knowledge from indigenous peoples, plants, and other types of medicinal wisdoms. We have something called the Earth Biogenome Project, which is an international endeavor to sequence like 10 million genomes. And as mentioned earlier, a lot of this novel discovery is going to take place in specimens that have been sourced from indigenous lands and are long stewarded collections. So the way to move forward, of course, is to incorporate indigenous peoples and local communities as partners in this sequencing endeavor. Next. I do want to call out the Native Biodata Consortium as an indigenous-led biological and data repository, which is using machine learning approaches as rooted in AI for federated learning and blockchaining to protect sequence data from eukaryotic species like plants and other types of animals that are culturally relevant, but also for those instances where we cannot recall or reclaim that material primarily. It's really interesting to have like something like local context emerge, which is a form of metadata labeling, which is labeling sequence data and other types of specimen data with provenance data and also cultural information, really to allow tracking and tracing of that information back to the indigenous peoples from which that knowledge and data has originated. Next. Finally, I want to state that, sorry, and when we're talking about equity, we have to think about equity, not just an engagement equity in involving indigenous peoples, but really ensuring that they have data decision-making equity and also benefit equity. And absent any movement across these three different axes, we are also just defaulting to a status quo and not really truly moving toward innovation. That we want to move toward innovation, we need to consider benefit sharing, ensuring that the benefits of research go more proximally to indigenous partners, acknowledging indigenous data sovereignty, rethinking data ownership towards stewardship models. This is actually something that the Canadian Intellectual Property Organization was of interest of hearing from me when I spoke to them last May, and also ensuring that innovation is aligned with equity. Next. Thank you.
Wonderful. Thank you, Crystal. That's very, very helpful. And thanks for setting kind of the context for us. I'm going to pass the baton over now to Forrest, who I think is on next.
Yep, thanks. So this is me, and just in the interest of time, I'll just go to the next slide. And as you could see in that prior one, I'm talking about patents, and so I thought the best place to start is just what is a patent? A patent is a piece of paper that gives the owner of that piece of paper an exclusive set of property rights to an invention. And those rights are specifically to make, use, sell, offer to sell, or import that invention into the United States. Usually when we say invention, sometimes the lay people, the mind jumps to like some sort of groundbreaking new, like the light bulb when it was first invented. But you can get a patent on incremental improvements. So like making a better light bulb or a better mousetrap or whatever, gets you a patent on that new light bulb or mousetrap. You don't have to have the first mousetrap or the first light bulb. Significantly, patents are of limited duration. It's a little bit more complicated than just 20 years, but for our purposes of our discussion, know that it's about 20 years that you get of essentially a monopoly on making, using, selling, offering to sell, or importing an invention. And then after that patent is expired, the information within that patent becomes part of the public domain, which was part of our discussion earlier today. So what does all this mean for traditional knowledge? Well, there's a couple different issues. One is that traditional knowledge may not be patentable at all. And all of these, patents don't, the patent laws don't draw distinctions between indigenous communities and non-indigenous communities or entities or people or organizations. So, when I say traditional knowledge may not be patentable, that's by tribes themselves or, people that are trying to exploit tribes. So either way, double-edged sword, it may not be patentable at all, but instead could be considered part of the public domain. To the extent that traditional knowledge is patentable, that's problematic because patents by people or entities or organizations that are not tribes or indigenous communities or indigenous organizations will then give those non-natives exclusive rights to the subject of the patent. So that would therefore exclude the indigenous communities from which the traditional knowledge came in the first place. And then I mentioned this notion of incremental improvements. So if there's traditional knowledge and then there's some sort of incremental improvement made upon it, that won't exclude the indigenous communities from practicing their, or using their traditional knowledge. But it just kind of seems unfair, I think, to most people that you could get a patent on this incremental improvement without any consent from the community from which the traditional knowledge came and without having to pay any royalties or benefits or anything back to them. Next. So to explain kind of those issues a little bit more, there's 5 basic requirements of patents. There has to be a patentable subject matter, utility, novelty, non-obviousness, and enablement. The subject matter, novelty, and non-obviousness requirements are all basically to ensure that there is something that is new. So you can't, as for subject matter, you can't patent an abstract idea, law of nature, or natural phenomena. Novelty means that whatever the patent is can't have been in what's called the prior art previously, and the non-obvious means it has to be a non-obvious improvement over the prior art. Prior art means prior patents, printed publications, things in public use, things on sale, or things that are otherwise available to the public. And this raises a lot of issues as it concerns traditional knowledge, because how those kind of requirements map onto traditional knowledge is kind of unclear, because it's a foreign context. So, for example, whether something is on sale, is straightforward in a commercial context, but when you talk about an indigenous community using traditional knowledge in the context of a gift economy, the indigenous community probably would say that's not on sale. It might even be offended if someone said that were on sale, but the dominant society could view that as being on sale. All of the public use or otherwise available to the public doesn't have to be a lot of people. There's a famous case from the 19th century about a guy that invented corset steels back in the day, like when European women would wear those corsets with like wires in them. And so this guy invented a new one and gave it to one person, and the court held that that was a public use. But the touchstone is whether the use is under some sort of condition of confidentiality or in secret. And a lot of indigenous traditional knowledge has unique types of confidentiality considerations that you might not see in the dominant society. So members of a certain clan may be able to know certain information, or members of another clan may not. And so there's, it's complicated in ways that the legal system can't necessarily grapple with, or hasn't grappled with yet anyways, which makes it difficult to know, is information prior art or not? Because if it is not prior art, then it can be patented. But if it is prior art, then, it can be used by anyone, unless it qualifies as a trade secret or there's some sort of unfair competition law, which usually wouldn't apply to traditional knowledge because those are all kind of pretty commercial specific. Next. So there's kind of a few different bad things that can happen in light of the kind of definitions in the patent system that we have. One of the bad things is what they call piracy, which is just purposefully taking traditional knowledge that maybe the dominant society doesn't know about, but someone finds out about and then wants to exploit it, and so they file a patent knowing that they didn't invent it, but just trying to get this commercial gain. A little bit less nefarious, but still pretty bad, would be the loss of control. And that's, when someone patents traditional knowledge, whether they know it or not, so like piracy, I view that as like purposely stealing something. You can innocently patent traditional knowledge if it's just independently come up with or something, I guess. But even if it's innocent in the state of mind, it still has the ability to exclude the community of origin. And also allow people outside of the community of origin to use the traditional knowledge. And then there's misappropriation or misuse, and that's using traditional knowledge without consent. Like maybe using it to come up with a derivative product and commercializing that, or using it in a way that violates customary law, like making a sacrilegious use of traditional knowledge. And Crystal, I think, was kind of alluded to that, talking about Sage as her example. So those are all the kinds of harms that can come from someone getting a patent on traditional knowledge. Next. So in light of that, there's been some attempts to address that, and you'll hear more about them. And I think there's kind of two different sides of the coin you have to look at. One is whether you can patent traditional knowledge. And strictly speaking, it shouldn't really be possible. Because all of this information has been going on for a long time, so it's not really shouldn't be a new invention or conceived as a new invention, but oftentimes there's just mistakes that are made, and there's been attempts to fix that. One is there's this duty of disclosure. Like piracy shouldn't, strictly speaking, be possible because people have this duty of disclosure. Now, sometimes people violate their duty of disclosure, and I think Aman is going to talk about kind of proposals to make the duty of disclosure more robust to prevent piracy. And then there's this idea that there's prior art searching done by patent examiners. So the patent office takes it upon itself to go and look around and see if something really is a new invention. And so if it's been in use by indigenous communities for a long time, then theoretically they should find it, but oftentimes they don't. And there was some very well publicized examples of failures of patent offices to do that. One was a patent on turmeric for wound healing, which was done for like millennia in India, but there was a patent issued on it nonetheless. And so there's a big push, and it's in the WIPO documents to push for what are called traditional knowledge databases, which will. The idea is to improve prior art searching, make it more accessible, translate it into English, put it in one spot to assist the patent offices to prevent the use of traditional knowledge, whether purposefully or inadvertently. One issue is that what do you do about secret traditional knowledge? Which I mentioned before. And so, technically speaking, is that prior art? Is it not prior art? How can you have, will indigenous communities and organizations and tribes be willing to put information into a database if it's not secret, if it's just publicly accessible? So that's not something that I know that has been part of the conversation, is how do you deal with that secret traditional knowledge? And then one thing that I just like to point out to make sure people keep in mind is that, these databases, they don't, and, a lot of the current proposals, they don't create any property right in traditional knowledge itself. They just are aimed at preventing people from patenting traditional knowledge, but that doesn't mean that indigenous communities get the exclusive right to use it and commercialize it. So other people can still commercialize it without a patent, right? Like, there was a long time, there was like these patent wars between Samsung and Apple on cell phones and who had the patents to cell phones. But if there's no patent on cell phones, that doesn't mean that the world will now have 0 cell phones. It just means that anyone can make a cell phone. So if there's no patents on traditional knowledge, it doesn't mean that only indigenous communities get to use it. It just means that everyone gets to use it. So along those lines, there's no property right to prevent offensive or sacrilegious use. There's no property right to prevent patenting of derivative inventions or selling derivative products. So those are kind of the gaps that still exist within the current framework, even if the duty of disclosure is made more robust, or even if prior art searching is improved. Thank you.
All right, thank you very much, Forrest. Let's go ahead and pass the baton over to Aman.
All right, thank you, Trevor, for moderating this panel, and my co-panelists for doing the sort of the heavy work of introducing this complicated concept, so that I have an easy task of just focusing on the disclosure of origin requirement. And I apologize, I don't have excellent pictures like Crystal had. So I have one picture of a patent claim, and so I'll talk about that in a bit. So this presentation is coming out of a few articles that I published, one of which is specifically on the disclosure of origin requirement, where I make the case for that requirement to be embedded in the domestic US Patent Act. Next slide, please. All right, so starting with the basics in terms of simple definition of the disclosure of origin requirement, it basically requires the patent applicant to disclose the source or origin of GR, which is genetic resource, TK, traditional knowledge, when they submit a patent application. And the purpose generally is to help the patent examiner have more information than they would have otherwise. And this sort of, in my work, I analyze this as a sort of balancing of the playing field in terms of information asymmetry. Right? The patent applicant has a lot of information, the examiner has limited information and limited time, and so disclosing any relevant information helps the patent examiner decide if that patent should be granted. Now, disclosure generally, as Forrest explained, is already present in the US patent system. So, for example, the enablement requirement says you have to give us enough information to allow a person with the average skill in your profession to be able to reproduce that invention that you're claiming. Of course, that requirement has changed over time through amendments to the Patent Act. More broadly, though, we do have a duty of disclosure, candor, and good faith, and more broadly, any time from the start of patent application until the patent is granted, you should engage with the patent office truthfully and in good faith. So even if it's not part of the strict requirement, there's this broader obligation of good faith. Now, the problem, though, is that traditional knowledge is not specifically mentioned anywhere in the USPTO, except to the extent of traditional knowledge digital libraries, which I'll talk about in a minute. So to my knowledge, I haven't seen traditional knowledge being referenced when patents are rejected. At least they're not done on a regular basis. And so that leaves the question of whether traditional knowledge is actually required to be disclosed. And when I say traditional knowledge, I'm using that broadly to include genetic resources, traditional knowledge specifically, and traditional cultural expressions. And so, is there that disclosure specifically when it deals with traditional knowledge? It's still not clear. It's not answered specifically by the USPTO. And so we'll see if in this process we'll have some clarification there. Next slide, please. All right, so what I want to do, I based on the panel conversations earlier today and this panel, I just want to make sure that we know there are three instruments at the international stage There's the genetic resources document, and it's, specifically saying genetic resources and associated traditional knowledge. But for short, I'll just say genetic resources. So that's the first draft instrument that's progressing into the diplomatic conference later this year. And then there's a separate document on traditional knowledge, and then a third document on traditional cultural expressions. So I'll focus on the genetic resources document since that's sort of the more urgent document. But my comments also deal with traditional knowledge independent of genetic resources. So the current status of the disclosure of origin requirement is that it's part of Article 3 of the genetic resources document. It's also part of Article 7 of the other document dealing with traditional knowledge. And so I was happy to see that in the document because it's one of those requirements that I think there could be a consensus around and effective action could be taken. The disclosure of origin requirement is also part of national laws in several countries. Now, as to be expected, right, a lot of global South countries where these resources are present have, because of the power that they hold to make domestic policy making, right, they've included specific disclosure of origin requirements. That is not the case in the US. As I said, specifically, we don't find that. A lot of global North countries, right, those are companies, the researchers against whom claims of biopiracy would be made are based. And so those countries have not created a disclosure of origin requirement. There are exceptions that I'll talk about in a minute, such as Switzerland, for example, but we don't see that happening consistently in the global North countries. Next slide, please. All right, so this is the document that I mentioned dealing with genetic resources and associated traditional knowledge. Article 3.1 tells us what the requirement is. So it specifically says where the claimed invention is materially / directly based on genetic resources, each contracting party, a member of the World Intellectual Property Organization, can require or shall require applicants to disclose the country of origin. Now note, I'm going to share the second part of this article, which is in contrast with this one. So this specifically says when the topic is genetic resources, what applicants are supposed to require to disclose is the origin, the country of origin, right? So it doesn't talk about communities necessarily at this stage. Now, subarticle B is saying, if you don't know the country of origin, just tell us where you got it from. So the source of that information, that means the source to you. So there could be other sources out there, but to the extent that you receive the genetic resource from an entity, it could be governmental, non-governmental, or even individuals, you have to disclose that. Next slide, please. Now, contrast that with the second subarticle, 3.2. Now, this is talking about traditional knowledge that is associated with genetic resources. So when it comes to the traditional knowledge aspect of the draft instrument, then indigenous peoples and local communities are mentioned, right? And this is tying this to the Convention on Biodiversity. At the international level, countries, right, sovereign countries are presumed to have ownership or have some sort of claim over genetic resources. And this was, of course, people on this panel and in the morning panel would know this more than I would know. During the negotiations of the Convention on Biodiversity, this came up and it was decided that countries, sovereign countries, would have ownership of genetic resources. And that's why we see the absence of mentioning of indigenous people in 3.1, but we see indigenous peoples and local communities in 3.2. So in case of an invention that uses traditional knowledge associated with genetic resources, then the applicant is required to disclose indigenous peoples or local communities that from which the knowledge originates. And this phrase also is consistently used, indigenous peoples and local communities, and that's depending on what phrase you're using, that could capture a smaller portion of the main phrase or more expansively. So if you use indigenous peoples and local communities, you're talking about communities that reside with settler communities or communities in countries where colonial forces have left the country, but they're still remains a community that's not part of the mainstream community, right? Here as well, if you don't know the origin of the traditional knowledge, specifically the indigenous people or local community, you're supposed to disclose the source. And again, this is supposed to help the patent examiner follow through and see if the source is somehow connected to an indigenous people or local community. Next slide, please. All right, so 3.1 and 3.2 are outlining what the requirement is of disclosure of origin. But if you remember that there's that phrase, the invention has to be materially or directly based off of a genetic resource. So Article 2, which is this article, the provision of the draft instrument that lists key concepts in the instrument, also gives us a definition of what is materially or directly related. In that definition, you see some sort of cyclical definition happening here. Basically says that the genetic resource or its associated TK must have been necessary or material to the development of the claimed invention, but at least it's helpful. It's expanding on that phrase. And then it goes on to say that the claimed invention must depend on the specific property of the genetic resource, right? So if you were to think of examples, simplified, of course, turmeric was mentioned as sort of having healing properties, right? If the source community is using it in that way to heal wounds of a patient, and then the pharmaceutical company is also using the active ingredient from turmeric to basically treat wounds, then the specific property of the genetic resource is used, and therefore disclosure is required. But if the source community is using it for one purpose and the pharmaceutical company discovers that it has completely unrelated, quote unquote, unrelated use, such as treatment of cancer, for example, then the argument is that the pharmaceutical company is not required to disclose source. And so that's still part of the discussion at the World Intellectual Property Organization. Next slide, please. All right, I mentioned I have one slide with pictures. This is it. I know it's not exciting, but I just wanted to show to members of the audience that might not be, if you're not aware of how patents are organized, right? There's the formal, inventor name and such. Parts of it, there's the abstract, and then there's the specification that situates the invention in the literature, right? So talking about other publications, other inventions and the like. And as my patent professor used to say, the name of the game is the claim, right? That's where you see the clear definition of what the property right the inventor is claiming. So the argument from experts in this area is that the triggering aspect of the disclosure of origin requirement is when an independent claim mentions specifically a genetic resource or associated traditional knowledge. So in the picture, Article 1 or Provision 1 here, or Claim 1 rather, and then Claim 8 would be independent claims, right? And so if a genetic resource or traditional knowledge is mentioned in 1 or 8, then the disclosure of origin requirement will be triggered, and therefore the applicant is supposed to disclose, if it's genetic resource, the country of origin; if it's associated traditional knowledge, the indigenous people or local community. If it is mentioned in claims 2 to 6, because they're dependent on the other claims, the argument might be that the requirement might not be triggered. Next slide. All right, so I'm going to switch over to the arguments for the disclosure of origin and arguments against it. So these are arguments made by proponents of the genetic resource and traditional knowledge protection. Usually this include representatives at the WIPO level, representatives of countries from the global south, and of course, even if in the absence of local or formal power at the WIPO, representatives of indigenous peoples and local communities, right? So even if voting power is not given, in my research, I've discovered that almost every representative of indigenous peoples and local communities is asking for clear protection of genetic resources and traditional knowledge, and specifically supporting the disclosure of origin requirement. So the arguments, even if this is simplifying complicated documents, I've tried to capture them in this 5 bullet points. One of the arguments is this is just asking for transparency. Just tell us, give us more information so that the patent examiner decides if the patent is worth granting. An implication of that is it empowers Indigenous peoples and local communities. It encourages benefit sharing. And this document is connected to the Convention on Biodiversity, to the Nagoya Protocol, which require benefit sharing systems to be set up. And of course, we are hoping that this discourages misappropriation or biopiracy in general. I've tried to make original arguments to engage entities that might argue against the disclosure of origin requirement. And what I've done is to basically use the efficiency argument that they use against the disclosure of origin argument, and then basically turn it on its head and say, there is an efficiency argument for the disclosure of origin requirement. And the paper is available on SSRN, and I'll be happy to talk about it in the Q&A. But the argument is that if we're talking about efficiency, we need to give the patent examiners as much information as possible so that we're not granting exclusive property rights over some things that are not inventive, or at least that we're giving the right scope of an invention, a right over an invention. And so I call that the protectionist, the argument for the disclosure of origin argument to address the protectionist trend, this trend that we see among Indigenous peoples and local communities and countries in the global south, where, if you're not protecting our interests, we're not even going to let you come into our land, our communities, and sort of shutting it out, right? The researchers are not even allowed to come in. And that protectionist trend, I believe, might result in a sort of lose-lose outcome. So I make the argument for an efficiency argument for the disclosure of origin requirement. Next slide, please. All right, so these are, again, arguments made by entities, usually governments of developed nations, against the disclosure of origin requirement. Now, this are, again, is a simplification of some of the claims, but if you see documents, for example, submitted by the US negotiators at WIPO, these claims keep coming up, right? So if you ask what's wrong with the disclosure of origin requirement, we're just asking for transparency, the response would be it's too burdensome, it's unworkable, it creates unpredictability in the patent system, which might discourage inventions in this area. It adds to the transaction costs, and again, transaction costs are expected to disincentivize innovative industries. And again, these are claims that are not necessarily backed up by evidence, but these are the claims that negotiators that are objecting to the requirement make. They also say that the public domain concept was mentioned earlier today as well. They say traditional knowledge and genetic resources are in the public domain, and therefore there's no reason to bring them into the patent system and sort of disclose elements of the public domain. And again, not to be dismissive of these arguments, but the argument seems to be basically around a single concept of this is just so hard to disclose and it's unnecessary that it might disrupt the inventive ecosystem, right? And so that's basically the argument against the disclosure of origin requirement, and sort of saying it's more expansive than just a transparency element. Next slide, please. In terms of why the disclosure of origin requirement might be relevant, in what way does it impact the patent system? Even before getting to genetic resources and traditional knowledge, I argue that even in the patent system, even if, think of the patent policymaker at the USPTO who's not interested in protecting traditional knowledge, that person should be interested in not granting patent rights to uninventive applications and granting the right scope of the patent, right? So it might not be that if the patent applicant sharing the genetic resource or traditional knowledge results in the rejection of the patent, but it might actually result in a narrowing down of the scope, right? And so even the most cynical player in the patent system should be in favor of the disclosure requirement because it helps the patent system. Now, beyond that, the relevance for the conversation around genetic resources and traditional knowledge is that, one, it allows for defensive protection, which is to say it allows communities to say, no, you can't claim my knowledge, you can't claim my resource. And so this requirement allows for those processes to take place. And more expansively, it actually might also allow the communities to claim rights, right? So communities could say, right, so-and-so has mentioned that they've received my genetic resource or traditional knowledge in their patent application, and that sort of as an evidence in the claim to make positive, active rights over the genetic resources and traditional knowledge. Now, that's to the extent that the community wants active rights over those resources and traditional knowledge. And if that's not required, of course, the positive protection should not be addressed. Next slide, please. Right, just to conclude, there is a strong efficiency argument in addition to the human rights arguments, the fairness arguments, the social justice arguments that I think should take the lead in this space. So I want to make sure that point is part of the conversation, that even in the efficiency ecosystem, we still need the disclosure requirement to be implemented in the US. This claim that the requirement would disrupt the innovation ecosystem is unfounded. I haven't seen evidence of that. If you're interested in this area, you should see the back and forth between the US patent office's response at WIPO, analyzing the Switzerland's disclosure of origin requirement, and of course the response from the Swiss government. That back and forth is sort of really interesting in terms of the claims that are made normally that are unfounded and what the Swiss government said is actually happening on the ground. So these experiences at WIPO, I think, show that this could be done. And sort of asking for perfection at the start of this process should not be required. I think we should let the system evolve over time. So I'll stop my remarks there. Thank you.
Thanks, Aman. Wonderful overview and very helpful there. Now, to zoom out just a little bit and see kind of how this provision might fit into the patchwork of international IP law, Jan Ose-Tutu will be presenting just a little bit about how to look at this kind of in a broader picture.
Thank you, Trevor, and thank you for including me in this conversation. I will wrap this up in like 8 minutes, so I'll be super fast. And let me just say, first of all, I'm grateful to be included in on this conversation. And why am I here? Just so you know, when I was a baby lawyer with DOJ in Canada, working for the Canadian Intellectual Property Office that Crystal mentioned earlier, and the Department of Industry, which is like the Department of Commerce, I have the TK files and the GI files. And so I was, this is like some 20 years ago that I started. And so I bring that perspective to these comments. Next, please. Okay, so I just want to, provide a bit of context in terms of ways to think about TK. And I started off very cynical, but I think there's been a shift, and that's what I want to talk about. I think there's been a shift in international IP, and I just want to talk about that as something to keep in mind. So just looking at this beyond WIPO, when we go back, there was the TRIPS agreement, the trade-related IP agreement at the World Trade Organization. So we've been talking about WIPO so far, but, the World Trade Organization is where we had enforceable IP rights, with the idea that you'd have this efficient trade and trickle-down theory. But what we've seen over the past several decades is that there's been really questioning of intellectual property on the international level, the claim that it's inequitable, that it's focused on wealth generation for industrialized countries. And so that has led to some shifts, right? So that it's not appropriate for less developed countries. We saw the critique around access to medicines, even in COVID. And I think that's actually a good thing in many ways for the conversation that's about to happen right now in terms of disclosure of genetic resources. And also because we saw at the WTO that nations were willing to protect European geographical indications for the first time in a multilateral agreement, but failed to protect traditional knowledge. And I mention that because if you think about, well, I won't go into a lot of detail about geographical indications, but basically if we think about things like champagne, right? So if they're saying that this thing has to be made in a particular way with a particular process that's been handed down through generations. And so you can see sort of the parallels with traditional knowledge and geographical indications, but the GIs are coming from a very European Western system already. So that was, I think, a really big move in international IP that has led to some questioning and some backlash in addition to the other things. Next. So how did we accommodate the global majority? And I say that because really it's pretty clear that the system's been structured for industrialized countries. I'm not the first one to say that. It's a very established critique. So we had this sort of flexibility for less developed countries, the focus on trips and public health. Next. So that kind of accommodating of the global majority. But now we have this really, I think, picking up in a way that maybe countries like the US had not anticipated. And I think it's really important to be clear that the United States is not seeking TK protection. And the United States, very clear, even in I think the videos that they had made for these consultations, they're not a demandeur, they prefer kind of a soft law approach. So one of the questions that you were asked, or that was asked that I saw was, how do you define traditional knowledge, right? It's not been decided how this has been defined. And one could take the national response, which is part of the strategy, right? How are you responding nationally based on local perspectives and vis-a-vis the US government? And then also there's the international approach, right? Which, one might want to respond taking into consideration what's happening in international IP law outside of WIPO, and keeping in mind that these international definitions are going to be broader and broader than national and local definitions, because you want to accommodate a range of perspectives and fit within that. So I'm going to talk about that international next. Okay, so with WIPO, we know there's no agreement yet. There's a consensus model, which means it's very easy to not have agreement. But when they ask about traditional knowledge, so there is the opportunity to either come up with your own terminology or just really draw on what WIPO already has. So it's not true that there's nothing there, right? So they have some existing definitions, but I'll also point out that there's no agreement in terms of WIPO, and this, I'm not going to read all of this, but just to sort of hone in on this idea of intangible cultural heritage that has been mentioned earlier today. We do have the Convention for the Safeguarding of Intangible Cultural Heritage. Next, please. And that 2003 Convention for the Safeguarding of Intangible Cultural Heritage, if you're going to look at the international sort of approach in terms of your response, I think it's really an important one. Now, the United States is not a party, but most countries in the world have signed or ratified this agreement, and it defines intangible cultural heritage. If you look at the language, practices, representations, expressions, knowledge, skills, basically it's talking about TK using a different definition that I would say is pretty well internationally accepted. So it's not as though there's nothing out there. Next. And I just wanted to talk briefly about some places where traditional knowledge is showing up also. That to me is an indication of sort of the shift that's happening in international IP. So there's already been discussion of the CBD that was enforced since 1993, the Nagoya Protocol that came in 2014, the UNDRIP, which was discussed earlier in today's program, but it's also, we're seeing traditional knowledge mentioned really interestingly to me in trade-related intellectual property agreements. So remember I started out talking about the WTO. You have these other regional agreements. So the WTO, most countries in the world are members of the WTO. But these other agreements are smaller, but they're still interesting in terms of the developments that we've seen there. So the RCEP and the CPTPP. You may recall that the United States pulled out of the TPP, that's the Trans-Pacific Partnership, but other countries went ahead with it. So it's called the Comprehensive and Progressive Trans-Pacific Partnership. Next. So you'll see TK popping up in the CPTPP and the RCEP. And here, the parties are recognizing IP systems and the TK associated with genetic resources. when the TK is related to IP systems. And also you see there that there's this language of a party, being so a country that's joined, may establish measures to protect TK, genetic resources, and folklore. So even leaving aside what WIPO is doing, there are countries, we know that they're doing it nationally, but there are also these agreements that are happening regionally. Next. And there's a CPTPP has also a provision on disclosure of traditional knowledge. Now, I would just note that it says that that the parties may include this. So the language is it's not obligatory. It's not something that countries that have signed on have to do, but still it's there, right? That when you're looking at prior art, you might look at what is the publicly available information related to TK and genetic resources and have an ability to cite in writing. So this is already, we see disclosure of genetic resources showing up in a trade-related agreement where they're talking about the intellectual property aspects. Next. So really, I would just, I'm going to conclude by saying that we do see these shifts in international IP. So I was very cynical, I would say, 20 years ago about what was going to happen. But, over the years, we've seen that international IP has been forced to respond to many different criticisms of the system, including the demands for TK protection and a more equitable system, which means that, in my view, there are a couple of options, right? One could try to fit into the existing framing, which is kind of an innovation model of IP, which people have talked about already today and how that has its limitations and how that doesn't work. And there's also the opportunity to reframe the conversation, which is already taking place. So it's not something that has to be reinvented. So we heard earlier today about human rights. They're the human development instruments in international law, the United Nations Sustainable Development Goals, which that can be pulled in and tied to different things that are happening in terms of what are we doing with intellectual property. And when you're talking about traditional knowledge that is related to genetic resources that is being managed or developed by an intellectual property organization. Next. And to me, one of the really striking examples of the shift in international IP is to have, again, coming back to the CPTPP, this language of reaffirming the importance of corporate social responsibility, cultural identity, diversity, environmental protection and conservation, indigenous rights, sustainable development, and traditional knowledge. This is in the preamble of the CPTPP. And I would just end with this because I think it's, one might say, well, what's the big deal? Well, look at where we were with the WTO agreement on trade-related intellectual property rights, and even at the NAFTA intellectual property chapters, it was always about trade and the sort of the economic incentives. But now there's this move, this shift that's happening to taking into consideration these other factors and how the system benefits or doesn't benefit everybody. So there is this shift in context in international IP. So in terms of timing, which is something that people mentioned earlier, I think this is really a great time to actually be able to draw on some of the trend in addition to whatever strategies people may come up with domestically. I'm at time, so thank you very much. And that's it. Thank you. Welcome your comments. Any questions?
Wonderful. Thank you, Jan. That was very, very helpful and giving us kind of all the interconnections with all these other agreements. And thank you all to each of you on this panel. It's super fascinating and very helpful to help us to understand how these mechanisms are going to work on the ground and how they dovetail with patent law and some of the other aspects of IP. So thank you very much. This has been wonderful. We're going to be jumping into our next panel, but before we do, I know we had a couple of hands up, some potential questions. So as Sue and Ryan are joining us for our brainstorming session next, I wanted to go ahead and recognize Peter Yu, who's a professor that works in this space and actually has a forthcoming article that will look at the WIPO negotiations. Peter, did you want to say a couple of words before we slide into the next panel?
Can you hear me?
Now we can hear you.
I can wait until next panel.
Okay.
I think Preston has his hand up though for some time. I don't know if he had a question.
Okay. Oh, yeah, I see it now. Preston, do you want to go ahead?
Sure. Most of mine probably could go in the next one, but I have several. There are a couple I wanted to clean up a few ideas. I wanted to address this issue that defensive protection means the right of communities to defend, and that may be one meaning, but I think the meaning within WIPO essentially means prior art. It boils down to prior art in the public domain. So we've always been against the word defensive because it really isn't about the rights of communities to protect. It's more about using traditional knowledge as a way to defend the knowledge against patents. But as was pointed out, once you go the prior art pathway, it doesn't really protect your knowledge per se. It just protects it against patenting. And we know that, a lot of the real harms come from non-patent uses of traditional knowledge. On the issue of the disclosure as transparency and disclosure as substantive. In the Nagoya Protocol, it is substantive. You are required to disclose PIC and math, prior informed consent. That's the language of Nagoya, or materially agreed terms. Now, in the current draft, it is just a transparency measure where states have to declare. And then there was an attempt to move the language from declare to explain, and we were thinking of supporting it, but then realized that declare is a better word, and that what we were offered was not strong. So at least they make a declaration, which potentially could lead to revocation of a patent, but understand that it doesn't automatically in the current text lead to revocation. There has to be other features like willful mischief and misappropriation and so on. Genetic resources, I don't know if we've really covered that, but we really have to get into it at some point because genetic resources means a very specific thing in international law. Genetic resources in the CBD means genetic material of actual or potential value. And genetic material means any material of plant, animal, microbial, or other origin containing functional units of heredity. Understand that this is a definition that refers to samples containing genes. It's not about the genes themselves, and actually that's really critical to understand. And it's very important now because we're negotiating something called digital sequence information under the CBD, and I don't know if we're going to get much into that, but it's critical. Digital sequence information is at the level of the genome of genes, whereas genetic resources is at the level of the sample. So biopiracy classically referred to, and also this is the understanding in UNDRIP, because it was the people who I know the people who drafted it, and I know the history, and it was based on the WIPO and CBD negotiations. They can't come and take a sample from your land and then do something without your free, prior, and informed consent. On the other hand, things move on their own, and genes move and assort on their own. They move off your territories and they move onto your territories. So with all this natural dispersal and so on going on, when we get down to the genetic information level, the sequences, there are some real problems that we haven't addressed. And I've read, a lot of articles, and I'm happy to talk with people about it, but you get into a different world. So that, I think people need to understand that. Let's see, the worry about the databases. Again, prior art databases, just to be clear, the databases that are proposed are not adding new primary traditional knowledge. They are merely compilations of existing publication databases like out of Nature and Science magazine. So they're not asking for states to start putting and gathering traditional knowledge, but they are doing it anyway through their researchers, right, who are creating these public documents. And so what we've said is, we're not against databases per se. And then also remember in the WIPO context, the databases they propose are limited only to patent offices. And of course, we've raised lots of alarms about that. But, you know, say they can secure that. It's just, you know, publication databases, and that does help in patent review. But what we have complained about is really without a substantive disclosure requirement. It's the disclosure requirement that should be taking the burden, not the publications. Because you should be saying, if you got something from indigenous people's lands, you should say that. If you got their knowledge or their genetic knowledge anywhere, actually. For genetic resources, if you got it from their lands, you should state that. And to me, that's actually just part of, you know, the state sovereignty over natural resources. Even states should be supporting that. You shouldn't be doing research on genetic resources that you don't know where it came from. You should always be able to state that. And again, domestically, for sure, I would say that's a really strong thing we should pursue. Thank you.
Wonderful. Thank you, Preston. Any responses or any additional thoughts from the panelists before we wrap up here and move on to the next? All right. Well, thank you so much, all of you. It's been a fantastic conversation. Looking forward to more. Now we're going to go ahead and jump into our next session where we're going to be brainstorming a bit about, you know, how do we approach this particular agreement, this draft agreement that's being presented. What are some of the ways that tribes might develop a position on this? How do they comment on it? How are they going to respond during consultation? And so I have joining me two folks that will be very helpful in this conversation, and folks that have helped me to learn quite a bit about it just over the course of time we've been meeting together. So we have here for our panel, this concluding panel, Sue Noe, again, from NARF, the Senior Staff Attorney at the Native American Rights Fund and co-director of the Implementation Project, and also Ryan Sela, Director of Policy and Legal at the National Congress of American Indians. So thank you both for being here. You know, we can kind of walk through a handful of questions that we have for both of you, and we can certainly share quite a bit of resources. I know we've talked about agreements, we've talked about various texts, and we've come across quite a few organizations that we can mention and highlight. We also have a number of folks that are on the panel or on the conversation today that are experts in this area, and we'd love to hear from them. I mentioned Peter Yu, who's also joined us. And so we'll go ahead and start. First of all, let me ask you both, can we talk just a little bit and just recap, you know, why is this particular agreement on genetic resources and associated traditional knowledge, why is it so important at this moment in time? You know, just to bring back some of our conversation from earlier in the morning, Sue, why is this such an important thing that's getting advanced at this moment?
Thanks, Trevor, and thanks to the panelists in the prior panel. That was so fantastic, and I wish all of you and all the speakers this morning could go to every session at WIPO and participate in the negotiations. So just to recap a little bit about the status of the negotiations and why the genetic resources and associated traditional knowledge instrument is particularly important at this juncture. So as we discussed, the negotiations at WIPO have been going on, or the conversations at WIPO, the negotiations for over 20 years. And in the course of that, these instruments have been negotiated in the IGC, this Intergovernmental Committee at WIPO. And it's only at this moment that a text is going to the next level, the diplomatic conference level, where it could possibly turn into a binding international instrument. So there's going to be this meeting in May, coming up May 13th through 24th, and where high-level diplomats are going to be putting the final touches on this instrument. And, you know, while the outcome of the diplomatic conference is unknown. You know, we've talked about how the US doesn't really want a binding international instrument. There is this potential right now at this moment for there to be the first ever finalized instrument coming out of these WIPO negotiations, which is really, really a significant milestone. I think there have been a lot of concern over the years that this process at WIPO would just go on and on forever. And I think as Preston had mentioned earlier, you know, the process was such in the negotiations that if any member state didn't agree to something, then, you know, it just, you know, a member state could put something in, another member state could put something else in. And it was just the sort of it was like 2 steps forward and 3 steps back, or, you know, kind of process. But to have this go forward in this way, I think it's really a critical moment. And now is the opportunity for tribes to have input on this document that can become a finalized instrument.
Wonderful. Well, and maybe at this point, maybe I could invite Peter to chime in just a little bit. I know you're an expert on the negotiations that went into this and are tracking this pretty closely. Do you have any thoughts on, you know, how did we get to this point? What's happening behind the scenes here?
So let me start with a few things based on my observations from the previous panelists, as well as from this morning. So I think it's important to separate the consultation for January from February. If you actually look at the questions from the USPTO call for comments, the 19 questions for the January session is completely different from the 18 questions you got from February. So there's some overlap, but for those of you guys who can put together resources, I strongly encourage you to do both. I think the first one will be the one that is designed primarily for those who do not know enough about indigenous culture, so that the rights holders can also weigh in on whether traditional knowledge and cultural protections and also disclosure will actually create a burden on business, on intellectual property rights holders. So to the extent that we actually want to respond to that, I think we should definitely get the comments in the first period as opposed to the second one, because you'll be able to engage with the conversation. I think it'll be very useful to actually talk about why there are a lot of misconception about the protection and why they actually exaggerate the burden on the rights holders and how that can be beneficial. So to the extent that you want to get those ideas out there, I think it'll be very useful. And for the second one is mainly about, so the first one is basically about both the disclosure requirement as well as sui generis rights. And the second one is mostly about the WIPO negotiations, the treaty text, and also the future negotiations on both the TK and TCE. I think it's important to keep in mind that we do have 2 other treaties. I think that ties to Trevor's question that's coming up. But it's also important to remember that since the creation of the IGC in 2000, it took 24 years before we got to a diplomatic meeting for the first treaty. There's no guarantee we actually will have the 2 instruments coming up basically in 5 years or even in 10 years, right? So to the extent that we are actually trying to push for more positive protection of traditional knowledge and traditional cultural expressions, then we might want to think about whether we want to try to get as much as what we can into this instrument, because the next instrument may be at least a decade later or something like that. I think there are 3 different things that would be quite useful for you guys. You try to engage with the draft text. One is the disclosure requirement. I think that goes to what Preston mentioned earlier on. I think it's a necessary compromise. You need to disclose enough to prevent the erroneous grant of patents, but at the same time, you don't want to disclose too much, and you don't want everybody to be accessible, right? So the key issue is how do you actually maintain control disclosure. So it's available only to certain people, but not over disclosed. And I think that would be important for those consultations. I think the benefit of having a general consultation is you can put as much as you want into the first consultation. If you still have more, you can put that in the second consultation, right? So I think that is something you can consider. Second one is about sections and remedies. I know a lot of folks from the different communities, both indigenous peoples as well as those who are helping indigenous peoples and local communities are not very happy with the sanctions remedies. So I think it will be important if you guys want to suggest anything to change from there. I think for information systems, it will be important to actually think about whether you actually want to have some concrete measures to be undertaken, especially how to protect confidential information. Right now, the treaty text basically talks about the way that we can actually explore down the road, set up a committee or something like that, right? But to the extent that you actually want to have some concrete ideas, I think it'll be important. Then I think the challenge for you guys is to think a little bit about how much you want to go into sui generis rights. What's the relationship with traditional knowledge and traditional and cultural expressions? The benefit of getting more into that is that you will give both the USPTO as well as the US negotiators a better understanding of how to negotiate and what to protect. The drawback of doing that is that if you mention a lot of different items, they can easily say that we will leave it for 2 other instruments that may never come in the next 5 years, right? So you have to figure out what's the best strategy to do that. And then I think based on our conversation this morning, I think it would be useful to actually get a little bit into the choice of instrument. It looks clearly that you guys want a treaty. You do not want to have, for example, a soft law recommendation toolkit. So I think that would be something you want to put in the consultation. I think you may also want to think about how to provide linkage to the different international instruments. Both the UN Declaration and the CBD were included initially, and the CBD were taken off. The declaration was kept there, but the language has moved to acknowledging, right? So you might want to think about how to actually, whether you actually need to do a little bit more in terms of pushing for the different linkage with other agreements, because I think we still have the provision on mutual supportiveness. So that's useful. But then the question is, it's very weak and it's very vague. And the chair's text basically take out most of the provisions from other international treaties by claiming in the comment that those treaties are already adopted elsewhere, so we don't need to repeat it. The drawback of not including that is that you cannot rely on other treaties to provide language to help you advance any discussion within this new instrument. So you might want to think about where you want to do that. And the final thing I want to end on is basically there are a few things that you might want to keep in mind. One is that this is an international minimum standard agreement. So for things like retroactivity, I think it's very hard to actually push for. I understand the concern, but at the same time, you can always increase protection. So I think the approach for the negotiators is that, well, we can only push for so much to the point that other countries like Japan, South Korea may actually not be on board, right? So I think we need to think about how to take advantage of the fact that it's international minimum standards. But at the same time, we also need to get, for example, PTO as well as others to understand that we may actually need to offer strong protection, at least domestically. For those countries that are very eager to have strong protection of TK and TCE, they will push for stronger protection domestically anyway. But for the US, I think that will be important. It will be important not to overlook the fact that we are now reaching a stage of diplomatic conference. I think Sue mentioned that a couple of times. I think a lot of those arguments that we can make in 2000 or in 2005 are not necessarily the arguments we can make at this point. So anytime we can change a few words or add a footnote that can actually change the interpretation of the text, that would be very useful, because they're not going to reopen a lot of the language that's been already negotiated. right? So think about where there are other things you can just add to a point that they can make a proposal and not renegotiate the entire sentence. I think it would be useful to keep in mind the institutional, keep in mind the history. And that also goes to what Trevor mentioned earlier on. So what Preston mentioned is very useful. Sometimes you might have text that's already included and then that's taken out later on, and then the negotiators will remember, right? So to the extent that you're trying to go for those text that has already been removed after a few years on a text, then it's probably not the most strategically useful to try to relitigate that type of issues. But at the same time, if you are if you believe that, well, that's a big mistake, we should put it back in, I think we should go for it. And one way to actually help to see what has been negotiated, what has been taken out, is that the IGC has very detailed reports about what type of textual language that has been removed and what type of things they have done. So you can always do keyword searches to find out where there's any relevant language. And I think I'll stop here and then we'll go back to Trevor and the other panelists.
Well, thank you so much, Professor Yu. It's wonderful to have your thoughts and insights, and thank you very much for joining us. You know, one of the great things about this session is that we're going to be able to have a lot of different perspectives on how to approach this consultation. And one of the perspectives that I think is really critical is that of the National Congress of American Indians. So we've asked them to be present for this brainstorming session to discuss their positions on the instrument and to help lead some brainstorming on the issues around genetic resources. But, you know, NCAI has been involved in this process for quite some time. In fact, I'm going to go ahead and post in the chat a couple of resolutions. And I'm wondering, Ryan, would you mind going through a little bit of how the NCAI position has developed over the years? I'm going to go ahead and send this out to everyone here so they have these documents.
Yes, thanks, Trevor. And thanks, thank you for inviting me to this panel and to Arizona State University for putting this together along with all the other partner orgs. So yeah, as mentioned, my background is as the Director of Policy at the National Congress of American Indians. So National Congress of American Indians, NCI, is a organization that is primarily has a mission focused on promoting tribal sovereignty, and the bulk of our membership in terms of driving our policy positions comes from tribal nation governments and from representatives of those tribal nation governments. And I think that's just important to note because it is different from some other organizations and from some other organizations that may participate in these conversations and provide comments. And my background is not in intellectual property rights. I am a lawyer, but I'm not an intellectual property rights lawyer, so all the experts are on this call. I do have a little bit of experience in international indigenous rights work, but it's also not my expertise. So I am really here to talk about, how does NCI sort of approach these types of questions for comment on, and approach some of what sort of information are we going to provide with respect to the consultations. And as Trevor put in the chat, NCI has been involved in this work largely through the Native American Rights Fund, through people like Sue, who have been acting, as NCAI's attorneys in this space for years and years and years. And over the course of time, over the course of the last 24 years, as the WIPO negotiations have played out, NCI has come together and passed two separate resolutions that you see in the chat. Now, these resolutions are the ways that NCAI develops its policy positions. NCI doesn't take positions typically on issues that there is no standing resolution on. And these policy resolutions go through a subcommittee and committee process, and the idea is to have as many voices at the table, and it is supposed to be a consensus-based process, so that the resolutions that are developed have the consensus-based positions of the tribal governments across the Indian country in the United States. You can take a look at those two resolutions. They're very similar. They're both calling, essentially for the same thing at different points in time. So the first resolution was passed in 2016. It's calling for the immediate and direct consultation by the United States with tribes regarding ongoing international negotiations at WIPO that may affect tribal sovereignty, including protection of indigenous traditional knowledge. You can see the last couple paragraphs of that resolution call specifically for consultation, largely with not just the United States Patent and Trademark Office, but with the United States government on a government-to-government basis. 6 years later, because 6 years later, and I will say in many attempts at getting that first resolution, action to be taken on that first resolution, National Congress of American Indians, tribal leaders came together again in 2022 in Sacramento and passed a second resolution, again calling for immediate nation-to-nation consultation with the federal government regarding negotiations in the World Intellectual Property Organization. So, you know, the position, the big picture position of NCAI is to start the dialogue, is that decisions are being made without tribal nations at the table, without tribal leaders at the table, without the people who are going to be impacted at the table, and that needs to change. And so in that sense, you know, these upcoming consultation sessions are a step in the right direction. We can talk, and Sue can definitely provide more details about the specifics, and we're going to, I think, walk through some of the specifics with respect to, you know, the genetic resources text and kind of where some of those positions are. I think the other, you know, component that I might be able to add at this point is sort of just how do you approach providing comments on something like this? You know, what is NCI's approach? How would a tribal leader or tribal government to think about doing comments on something of this nature? And we can again talk about some of the specifics, but I think, you know, big picture, you know, NCI's, I think, philosophy for a long time has been that to first and foremost to say something. Is that if you say nothing, you're not, you know, there's no chance of you being heard one way or the other. And so I think I echo sentiments that have been said up and down this conversation all day, which is, you know, no matter what capacity your tribal nation may have, your tribal government, or your organization, since organizations are invited to comment as well, you know, saying something is critical just to make the U.S. government aware that this is an issue of importance. And whether that includes, you know, just a basic statement of some sort of desire to see protection, or some sort of statement of basic principles that, you know, that your organization or that your tribal nation believes are relevant to the conversation, or even just a statement stating you would like to participate, but there's a capacity issue, and stating what those capacity needs would be to fully participate. All of those statements, I think, carry great value, and just being heard is sort of the first step. That's the only reason that these consultation sessions, I think, have been announced in the first place, is that there were lots of voices over a sustained period of time saying that this is important. I think the other piece I'll just mention in terms of how NCI approaches some of these comments is, and this is a difficult road to walk sometimes, especially, I would say, especially in this particular context, when there are so many different questions between the two different consultation sets of questions. You have a set of 19 very specific technical questions. You have a set of 18 questions that are kind of more broad and open, but is to try to, you know, when we submit comments on behalf of NCI, we're trying to walk the line of both mentioning the ideal and then also mentioning the practical. And I think, as I mentioned earlier in the session, you know, NCI intends to put out some talking points in the next few days, as well as some draft comments, or at least ideas related to draft comments. And I believe you'll see that sort of reflected in those comments. And you'll see that there is a need to talk about the ideal. There's a need to talk about what an ideal consultation process would have looked like over the last 24 years, and what it should look like for the next 24 years. And there's a need to talk about, you know, what would an ideal system of protection for genetic resources, for example, look like. But then there is also this need to address, at least on some level, the questions that are posed. So again, that there's not silence on those points, so that it's very clear what tribal nations and tribal organizations believe in those places and what they want to see move forward. And then I think the third sort of factor that NCI is always keenly aware of is that, you know, consultation is supposed to be a dialogue. I try very hard to make distinctions between consultation sessions, what's happening in January, or consultation sessions. Consultation is a much longer process, and it doesn't end, it's ongoing. And so I think when providing comments, there's this great desire to say everything all at once, or to feel like you have to have all the information and everything all at once to give to the federal government. But I guess I would urge that whatever information you have right now is valuable, and that a call to continue the conversation is equally as valuable. It was only the call for to have the conversation through, for example, the NCI resolutions and through other similar mechanisms that got us to this point to begin with. And so anything that is going to indicate that this is a dialogue that needs to happen over the next 10, 20, 30 years still is, I think, equally important. So I guess those are sort of the big picture approaches. And like I said, NCI along with the National Native American Bar Association we're both going to provide at least some guidance that we can, so that people can draw from that and take from that. And we're happy to talk about either the broad issues or the specific issues with the time that's left. I know a lot of it has been covered in great detail. This has been an amazing event for me personally to be able to learn a lot more of the intricacies on these issues as well. So I'm very grateful to have the opportunity to be here.
Well, thank you, Ryan. And that was, I really appreciate that. And reiterating that, when the comments are created, they can target both the process and what we'd like to see going forward, and also the substance of some of these questions. I know one of the substantive questions that came up in this last panel was, and what Preston raised was, what is a genetic resource, right? How is that term defined? Do you have any information, both Sue and Ryan, about how your organizations go about tackling this question? I mean, it seems like it could be a little bit complicated for tribal leaders to try to frame this even and try to make sense of what they should be advocating for. So either one of you want to tackle this and give us some guidance on that?
Well, I'm happy to jump in. Earlier we had a presentation that explained the definition of genetic resources as it's used in the genetic resources document, right? And that's the definition that comes from the Convention on Biological Diversity. That's genetic resources are any material of plant, animal, microbial, or other origin containing functional uses of heredity, functional units of heredity that have actual or potential value. But then the question of how Indigenous peoples themselves would characterize genetic resources is a different question. We know why this Convention on Biological Diversity definition is included is because that this instrument is in some ways, intended to be supportive of the Convention on Biological Diversity, HA, and the Nagoya Protocol. But that doesn't mean that this is necessarily the definition that is most suitable for our purposes. I did want to mention one thing that I don't know if anyone has mentioned this yet, but the term isn't intended to include human genetic resources. I saw that question earlier. And so like in the Convention on Biological Diversity, it's not part of this definition here. So I don't know, Ryan, would you have more to add about that?
I think all I would have to add, I guess, is probably jumps off of what I just said, which is I think with respect to, at least with these sort of questions that they're asking for comments on, that USPTO is asking for comments on, I think if to the extent tribal nations have a working definition, or even just just an idea of what they're talking about and what they want covered, that is useful information. I think again, it's easy to look at the technical nature of this work and to use that as a reason to be silent, because you want to talk about the parsing out the specific wording definition and whether whether it's X or Y. And I mean, that obviously that work has to get done, and that's what the negotiations at WIPO are dealing with on some level. But I think here the United States and by proxy the world hearing from indigenous peoples about what their understanding is, and if genetic resources, is a concept that looks very different to tribal nations, to indigenous populations, that's something that is incredibly valuable to be said. So I think like in any legal writing or any scientific writing, it's a good rule of thumb to just state your definitions and state your assumptions. So in that sense, I don't think it has to line up with what's being said, as long as there's a way to, for you to indicate what you're talking about, what matters to you, what you want protected in your community. I think that's what it looks like. And obviously, Sue and I and NCI leadership are going to have to sort out a little bit of how we approach that topic with respect to the comments, but I think it's getting to the same ideas. It's what is in need of being protected, more so than the specific wording of the definitions with respect to starting the dialogue. Again, this is dialogue that should have happened 20 years ago, but I think it's important to not feel like you have to rush to the end just because there's this 3-month timeline. Sort of. I guess that's the only other piece of it.
Okay, so just to kind of bring in the question that was asked in the Q&A from Ashlyn, she says on the topic of genetic resources, what about human genetic resources? She mentions that the field of personalized medicine is already sourcing the genome of indigenous and isolated populations for drug development. So if a tribal nation is really concerned about human genetic resources, even though the current definitions may not include human genetic resources, they should go ahead and talk about it, right? They should bring it up in their comments or in the consultation because it's important to them. Is that roughly what you're saying, that we should just get this conversation going?
Yeah, absolutely. I mean, I think again, there are on the practical side, right? There are specific questions that are being negotiated at WIPO, and I don't want to in no way try to diminish or dismiss those, but I do think the United States needs to hear from tribal leaders and tribal nations on these issues, and if that means hearing things that have been sort of agreed upon or set aside in the past, I still think that's valuable information. I don't know if it's realistic to think that the United States is going to change its position overnight, but without having those conversations, you can't have any of that change. So if that's an issue that's of importance, absolutely, I think that's something that should be raised.
Fantastic. Did anyone from the audience want to chime in about, specific genetic resources they're concerned about in their community, or, maybe their approach to dealing with genetic resources in that language that's included in this document? If you do, I've got the participant list open, and feel free to just raise your hand, and we're happy to give you that ability to talk and unmute yourself. As we're discussing more and more of the details of this agreement, I know another provision here that we've been talking about is this disclosure requirement. The current draft requires a disclosure in certain circumstances. One of the questions that you both have raised to me is, what about what do indigenous peoples want to have disclosed, right? What should be disclosed on a patent application? Is it just the source? Is it just the country of origin? Or should it be something broader than that, right? Another question to ask here too is, when are these disclosure requirements triggered? Is it every patent application? Is it, how robust should this be? And what should be the consequences, right? So maybe, Sue, could I ask you, could you touch on this a little bit? And, how is NCAI, how is NARP approaching this particular provision? And what might we be thinking about in terms of potential positions on this?
Thanks for that. I do want to circle back a little bit on the human genetic resources, and just to add sort of an asterisk to that, because that is an issue that we see the US asking about in the public comment questions. And it's not really an issue that's actively been negotiated. It's been pretty much accepted at WIPO that the definition would not include human genetic resources. And so there's a concern that, well, there was a statement issued by the, I think it was the International Chamber of Commerce or the U.S. Chamber of Commerce. I'm sorry if I'm misspeaking, but one or the other, where they raised the, if the scope extended to human genetic resources, then that would make this all way too complicated and not workable. So anyway, I just want to add that I do agree that, and this is, as Ryan was saying, we have things that we have to sort out at NCAI. So I'm just kind of noting that is something that maybe to be careful that we not give the U.S. any rationale from us about or any input from our side that would seem to give ammunition for being opposed to. Anyway, I'm speaking too much about this because it's not going to be included, just given the state of the negotiations, but just wanted to flag that for what it's worth. But on what should be disclosed, as Ryan was saying earlier, we have sort of our ideal and then the more pragmatic, practical, given the status of the negotiations, what is achievable. And I think ideally, so right now, as was described earlier, the disclosure of origin requirement just requires disclosure of the origin of genetic resources and associated traditional knowledge, or the source if the patent applicant says that they don't know the origin of that. So this is to Peter's point as well with the linkage. One other component of that we've proposed in the past is that there should also be a disclosure of compliance with any access and benefit sharing requirement, or an affirmation of free, prior, and informed consent for use of traditional knowledge, right? And then also there is a provision right now that would allow the patent applicant, if they say, well, we don't know the origin or the source, to just make a declaration to that effect. And one thing that we emphasized in the special session that happened in September, and I felt like there was a number of member states who were supporting it, is in that instance, there should be at least some declaration or affirmation of we exercise due diligence to try to find that out and weren't able to. I mean, we think ideally that provision should be deleted, because is it really, a reasonable circumstance that a patent applicant would not know either the origin or the source where they got traditional knowledge or genetic resources. So those are a couple of things on that. And I see hand raised, and so I'm sure lots of others want to chime in. So.
All right. So I saw Peter's hand up first, and then Professor Carpenter, and then Aaron Jones. So we'll start with Peter.
So let me try to break it down in case it might be helpful to people who are filing comments. So the disclosure requirement can be broken down into 3 different things, and that's in Article 3. The first one is the opportunity to ratify failure. So you can actually get into how soon they can ratify the failure, what they need to do in order to ratify failure, whether you actually get a chance to do it. The second issue is whether there's an obligation to verify. And I suspect this is a non-starter for the negotiation, because a lot of those countries that have very active patent offices, they do not want to take on this burden. So I don't think it'll be easy to negotiate, but at the same time, it's right there. And the third one is how we can actually protect different types of confidential information. And that's why I asked a question about whether we need to think about the tier system. And I think Preston's response is very useful. I think we need to look at, for example, tier approach as a necessary compromise, similar to disclosure, right? So if you actually will not break it down into different tiers, you will have more countries fighting against additional obligations with respect to information system. If you actually break it down into tiers, then it would raise up the problems that Preston mentioned, but it will be more palatable for some countries because they think it's more manageable for them to do that. So those are in Article 3. Article 6 is about sanctions and remedies. I think most people consider sanctions and remedies are not sufficient. I think Sue mentioned earlier on about due diligence. It's important to remind that if you have fraudulent application, you will be able to get different type of remedies, right? So it's not that you cannot get it. The difficulty is that you go from not having due diligence to fraudulent. There's basically a wide spectrum, right? So there are a lot of things in between. So then the question is you need to think about whether you need to offer any suggestion in the comment as to like, we need to go more than just fraudulent. We need to go further than that, right? So when there's, for example, some knowledge or notice, they choose to ignore it. Would that be closer to willful blindness, right? So there are some of those arguments you can make. And then the last one is basically about the information systems. And what Sue mentioned brings back some of the early discussion we have in the drafting session about whether indigenous peoples can actually contact the PTO to actually correct any wrong sources or misattribution, right? It's not in the treaty text, right? So to the extent that you actually care about that, I think it'll be very important.
Thank you very much, Professor Yu, for all of those points. Professor Carpenter?
I'd like to defer to Aaron. My point is a little bit big picture, and he might be on the technical point.
I'm worried I'm big picture as well, but thanks for the deferral. I'm really enjoying this conversation, and when it comes to genetic resources in this comments period, I think just in light of the diplomatic conference coming up in May, it's really important on any points, I guess, that you or your tribe or tribal leaders like want to raise in this issue, like what Ryan said. Just feel free to speak about it. Obviously, don't be afraid to talk about your interconnectedness with any type of natural resource or plants and whatever it is that is important to you and your tribe. You don't have to disclose, of course, medicinal plants. I don't think I wouldn't disclose medicinal plants, in this type of consultation unless it's in this notion of like something that's widely diffused. But for examples of genetic resources that are widely diffused or just widely known about, from Tulalip's perspective, salmon is such a cornerstone species for my culture, but also for Western Washington. Everyone knows what salmon is out here, and that's a genetic resource that we're pretty confident in bringing up as if there are samples being taken of salmon in our usual and accustomed areas for fishing, that's something we'd want to be consulted with if a patent application was using these salmon, like the salmon oil from these specific salmons, or and I know Preston brought up and then a few of our panelists this afternoon brought up the mention of that databases could exist for those things that could be considered prior art, or in other cases the patent offices may want key examples of what are important genetic resources to specific tribes. And I know we've developed some principles for databases that patent offices and any other database developer and user should keep in mind. And I would invite Sue to bring that up, or Ryan. And it's but I do think sometimes databases could be unavoidable as we get into the genetic resource realm. But as much as possible, safeguarding and protecting medicinal plants from being inappropriately disclosed to a wider audience or to the public.
Thank you. Thanks, Aaron.
Maybe I will chime in now. Thanks so much to Sue and Ryan and Aaron and Peter. It's great to see you. And thank you for your comments. So I have one question, and Sue, I think it's mostly directed to you. and then one comment. So the question is, in consultations and comments to PTO, we've talked a lot about the substance, and I'm also concerned about kind of the diplomatic posture and what's actually going to go on during the 2 weeks at WIPO. And I guess what I mean is that there's going to be, I imagine, back and forth on the text. And are there certain baselines that NCAI, tribes generally in the US, the Indigenous Peoples Caucus internationally would like to establish? For example, if it's possible that the reference to the UN declaration were going to be removed from the text, or the disclosure requirement was going to be taken out, would NCAI, tribes, the Indigenous Peoples Caucus like to withdraw their support, or like to instruct PTO on the front end that they wouldn't support an instrument without those, bare minimums? Because that's all going to be happening during 2 weeks in Geneva, when, this group of people won't be on the phone. And, how much can we kind of preview what the sticking points might be, but not only the stickiest points, like the really big picture items where, it would be terrible for this instrument to go forward at all if it didn't do, at least in my view, those two things. So, Sue, I know you've been, more than any of us, I think, there over many years, and Erin very powerfully too. So I welcome your thoughts on that. And then secondly, this is more of a comment, and I'll try to put it in the chat, but the implementation project, for anybody who's not on our mailing list, will probably do, a follow-up message to this session. And we do sometimes work with tribes and others to prepare for meetings with the United States. And I don't want to offer anything too specific because we've been very engaged in this wonderful webinar. But I'll put our contact information if folks want to stay in touch with us beyond this meeting. Thank you.
Thanks for that, Kristen. And I do want to circle back after to some of the information systems discussion, but to address a little bit, again, this is something working with Ryan and others at NCAI that we're still in the process of formulating our positions on things like that. But just looking at the diplomatic conference itself, this is supposed to be the very end of the negotiations, right? And so this isn't a moment for member states to be reopening a lot of the issues, to go back to definition of genetic resources, even the disclosure of origin requirement. But you raise a really interesting question about what if, I don't foresee that there would be a possibility that member states would agree to remove that from the instrument, but it's certainly good to be prepared in case something very unexpected like that were to happen. We talked about how in the IGC, the way that any member state could insert something in the text, and there were so many brackets and all these different conflicting positions on things and alternative provisions. And that's really the diplomatic conference is toward convergence on something. So I think any dramatic changes aren't going to be very welcome. And sorry, my office light's on a timer and it just decided to go out. So I think, but one is sort of scenario you've got me thinking is, what if member states were to say, well, you know what, we're going to take associated traditional knowledge out of this, because that's one position that some member states have had in the past, was a GR is okay, but no associated traditional knowledge, that's too complicated, we don't know how to figure it out, and that sort of thing. So I think, again, I have to consult with Ryan and develop, and get instructions from NCAI and and work with NCI on positions, but to me, that would be kind of the level of something that would be a point where Indigenous peoples may say, well, we can't support something going forward that leaves out associated traditional knowledge. We didn't come all these years, all this way to have some kind of instrument go forward without that. And another point to keep in mind about the diplomatic conferences, while in the IGC negotiations, in large part, the member states have tried to work on the basis of consensus. There is the possibility for voting in the diplomatic conference. So member states, I think it's a 2/3 majority. I'd have to find the rules of procedure right quick. It's either 2/3 or 3/4 majority, but they can vote on it. And, it's really the vast majority of member states who support a disclosure of origin requirement. There's really only a small handful, maybe 3, US being one, who would prefer not to have a mandatory disclosure of origin requirement. So I don't know if that answered the question.
No, thank you. And I know there may be, many issues that come up, but I do appreciate that this is supposed to be getting it over the finish line. And Peter made the point earlier that, the moment to make big points has passed. But I guess I feel a little bit nervous about where the US is going to come out on some of these things, and to the extent that in the consultations we can, provide some instruction. I realize that's an overstatement. The US isn't taking instruction, but some preferences from tribal groups, that would be brilliant. And I know I'm not moderating, but I see that Peter has his hand up.
Go ahead, Peter.
So I think a lot of the language in the text will not be removed because I think US is a minority along with Japan and South Korea. So I think the interesting question would be whether the US would take the same position as the UNESCO declarations, where they'll try to water down the language and then eventually not join this new instrument, right? So I think that is one option that might actually come out. I think another option that might come out, considering how important the current system is to the US, is that they might want to remove some of the language from there, but then some of the member states will actually want to include that as a brief statement toward the very end. And so we have seen this in some of the WIPO treaties, where the negotiation got dragged on beyond the deadline, and they still could not reach the agreement, and some of the delegates have already left, and they eventually have to negotiate a brief statement. So to the extent that you guys actually want to think about that type of situation, think about what type of agreed statement would be useful, because it might not, most of the time agreed statement is basically the language you cut from the text. And so you end up with the agreed statement because people cannot adopt it as part of the text, but they want to still keep it. But at the same time, if there are some confusion as to what's included or what type of additional obligations should be included, then it cannot be, it can be quite helpful to actually put in language so that it's ready for people to use when they need to do agreed statement. Our third thing, I think, is what Preston mentioned. If you guys try to team up with other negotiators from other countries, I think that can be very helpful, right? So ultimately, WIPO is a member-driven organization. So you need a country to actually offer any changes, right? So to the extent that you can team up with them, even if the USPTO is not, if the US delegates are not willing to do it, other delegates are willing to do it, and that can be quite helpful, right? So, the question that Kristen asked is actually a good one. So let me pass the ball back to Sue, right? So in a consultation, do you want to include certain red lines so that they actually know, right, what type of things they should at least not try to support when, for example, in terms of like removing certain language in a text. So I'm curious as to where you want to go so far, right? So you can actually say, what do we want? But you can also say that, well, those are things we must have. And so if you're going to touch that, back off, right? So I'm curious as to what you guys think strategically.
Ryan, is there anything you would like to say?
So there is, I mean, one of the questions that is posed is sort of, if you're thinking about protecting rights, what are the essential components? I think that's an important question to think, to put that information out. And I think that can go as specific as you want. I think, listening to this conversation, it's definitely given me some more to think about and to talk about with my own colleagues. But I will say, my personal, I guess, more personal opinion at this moment in time, since it hasn't been ratified by anyone else, is makes me uncomfortable to say, that a certain document is supported or unsupported until the final text exists. And so I think highlighting what the principles are that need to be in there is critical. To the extent you can do the opposite and say, like, if this were removed, this would be we wouldn't see this as protecting our rights. I think that's valuable as well. And I also think it goes a little bit to, it goes a little bit to the process too. I think there's, again, I don't know that anything will happen in this vein, but I think, calling on the process to keep Indigenous peoples in this country informed of those negotiations in a more effective manner than what has happened in the past as they're happening. And I know it's all very fast, in a very compressed timeline, but I think that's valuable. Or just making it clear that, if a particular tribal nation doesn't want the United States saying that, that their tribal nations all support this document, then I think you can make that clear as well by saying, we're not speaking to hypothetical text. We're speaking to, what's been put in front of us right now, or we're speaking to these principles that are important to us. Red lines. I'm only speaking from most of my work is with Congress. Red lines make me very uncomfortable, because they can be taken and used in kind of, they can be positively used and kind of used in more nefarious ways, I think. But that's just my opinion. It's not a blanket statement. So that's sort of, I guess, my initial reaction. I don't know, Sue, if that jives with with your experience, but curious if you have other thoughts.
Yeah, no, I would agree with that.
Well, can I ask, so one of the questions that Ryan and Sue had raised here was, should there be more of a presence of Indigenous peoples in this instrument, right? So we have the mention of the UN Declaration. We have kind of a general statement about the source, including Indigenous peoples in terms of disclosure. But, should there be a right that Indigenous peoples have to intervene? I think Peter may have mentioned this as well. I just wanted to hear a little bit more about that. Does NCAI have a position on that? Is that one of the red lines that you're thinking about? Curious about that.
Yeah, I think, NCAI's position is, tribal nations are sovereign, and the United States has a sovereign to sovereign relationship with tribal nations. So absolutely, they should be involved in that process. And the Indigenous peoples more broadly should be involved in the process. Anything that's impacting, directly impacting Indigenous peoples, the principles of FPIC and consent, those types of principles absolutely should be there, so that involvement should happen. And before I turn it over to Sue to add whatever additional comments she has, one other thing I wanted to say, just on the last point, is also that I think, to the extent, I'm say this very carefully, to the extent that maybe tribal nations and tribal leaders are unfamiliar with USPTO or don't particularly have this relationship with USPTO, I think it's good to remind tribal leaders and remind, more importantly, the United States that it's the United States that has that relationship with tribal nations, and it's their responsibility, which means the State Department, Interior, these other commerce, these different agencies that tribes may have a better relationship with, absolutely could and maybe should be involved. And I think that's also something that tribal nations can make clear in their comments is, maybe if hypothetically, if a tribal nation felt more comfortable with some DOI personnel involved in the WIPO negotiations for those 2 weeks, I think that's a totally legitimate thing to ask for. because they have had a stronger relationship over time and might be able to speak to some of, they're not a proxy for tribal nations by any means, but they may have a better understanding of what provisions, if they were to be altered in those 2 weeks, would impact tribal nations and what tribal nations' responses might be. And so I think that's another kind of route that could be taken with some of the comments. But I'll turn it back over to Sue on the other issue.
Thanks, Ryan. And yes, I think it would be fantastic if Interior, State Department, and yeah, we had support from our trustee, there. So in terms of the specific language in the instrument, we have proposed in different provisions, always including reference to Indigenous peoples' involvement. So like, for example, the provision on exceptions and limitations, where there would be an exception to the disclosure requirement. First of all, we say don't need to be any exceptions and limitations because it's a disclosure of origin requirement, and it's hard to envision circumstances where you couldn't disclose where you got something. But even if there were exceptions and limitations, they should be developed in consultation with Indigenous peoples, right? Sanctions and remedies, same thing. Any sanctions and remedies developed at the national level should be developed in conjunction with Indigenous peoples. And going back to the information systems, Indigenous people should be involved in any technical working groups set up to design safeguards or anything related to those information systems. And specifically, and Peter and others were part of this drafting group that worked on developing database proposals. And we came up with 3 guiding principles for those information systems, that there would need to be free, prior, and informed consent for database creation, content access, uses, safeguards, be developed and carried out in conjunction with Indigenous peoples and take into account their own laws and protocols, that these information systems do no harm in the sense that they must not infringe the rights of Indigenous peoples, like by facilitating misappropriation or misuse, and information being included in the information systems or traditional knowledge or cultural expressions included in the information system should not be considered to be in the public domain. And finally, that Indigenous peoples must have the right to access, remove, and correct any information inappropriately sourced or incorporated and confidential, culturally sensitive, sacred, or secret information. So those are just some examples of the different provisions where we've advocated to insert Indigenous people's involvement, and also many references as well in the traditional knowledge, traditional cultural expressions, and genetic resources context of reference to Indigenous people's own laws, customs, and traditions.
Wonderful. Thank you, Sue and Ryan, for that. So our panel time has expired, but we do have kind of this built-in segment where we'd like to talk a little bit about what people feel about outcomes. What would you like to see come out of these negotiations, about the consultations, about the comment period? What do we want to actually see happen? And that's the last segment. And I'm wondering, Ryan, Sue, and Kristen, and Peter, maybe you all, if you have time to stick on with us, what outcomes are you looking for in terms of this particular process? Do we want to set a new agenda in terms of how we work with the USPTO, how tribes are engaging? Are there particular outcomes we'd like to see at WIPO because of this? What kinds of things do we want to see come out of this opportunity that tribes have to go in there and have their voice heard? I'm not sure who wants to jump in first, but trying to see who's looking eager right now. Go ahead, Peter.
So I think my answer to your question will be somewhat different, depending on how quickly we move on to the other 2 instruments. If we are not going to move on to the other 2 instruments quickly, I think it will be useful to use the process to try to set up a good relationship for implementation purposes, right? So a lot of discussion today basically talks about the fact that even if you get the instrument, it will take some time before we implement it. So there will be a long process in terms of what type of system we need to develop, what type of new laws we need to draft. And so I think it will be useful that way. To the extent that we're not going to have, to the extent that we're actually going to have the two other instruments, then I think it will be useful to use the process to actually get the US government staffers to actually educate it about what issues are important, what type of things you can actually push further in the next 2 rounds of negotiations. I think one thing that has not been discussed here for the whole day is that there's some horse trading going on at WIPO when you get both the design law treaty as well as the current instrument at the same time, right? So if we're going to go for the next two instruments, then there's a question as to what will be the carrot that can be thrown out, right? To get US, Japan, and South Korea and other strong or other vocal countries that have been somewhat opposing the instrument to actually go on board, right? So at the moment, it's not that clear, right? That's why I'm somewhat pessimistic in terms of how quickly we can get into the two other instruments, even though IGC was working very hard in trying to actually develop the draft text for the other instruments. But ultimately, I'm a realist, right? So I believe that you need to provide the incentive for other countries who are not that supportive of TK and TCE to actually get to the table. And the easy way to do it is they want another treaty. And we do have that right here. And that's why you can fast track to a diplomatic conference. But I think the process will be useful in trying to develop good relationship so that they will be in a good position to figure out what other things can be actually bring together so that we can move on to the next two instruments.
Fantastic, thank you. Let's see, Ryan, did you want to chime in here?
Sure. I think, with respect to the instrument itself, I'm hoping that the United States gets some clarity on some of the kind of the most important issues, some of the disclosure issues, the sort of a database kind of issues, that they get some, that at least they would know where tribal nations, tribal leaders stand on some of those kind of key details, so they can't sort of play the card of not saying they don't know or saying, that maybe there's support one way or the other, but so it's a little clear. But I mean, I think, and this is definitely coming at it, a little bit from my position, which is more, nationally based than internationally focused. But I really hope that, a big outcome is just that the United States and USPTO in particular, hear from tribal nations that they see there's interest in these issues and that they see that these issues impact tribal nations, and that, regardless, again, maybe that the capacity isn't there for tribal nations to fully participate at this moment in time, but to see that these things matter to tribes and to tribal communities, I think is huge, because I think, it's been, there's 24 years of not talking to tribes in this country. And if you think about what the document looks like, it's without talking to tribes, it's sort of amazing to think about what it could look like if there had been 24 years of dialogue going up to this moment. And so I think making, these consultations about setting up that relationship or strengthening that relationship with the United States and with the USPTO, and saying, obviously we can't undo the last 24 years, but what do we want the next 20 years to look like, so these instruments can be stronger and can be more representative is, I guess, my sort of big picture hope. And I think it has to start with some engagement and with just requesting more engagement going forward.
Wonderful. Yeah, more engagement, more. Certainly, there's been a lot of talk about free, prior, and informed consent being kind of a major goal that we want to drive home. So thank you for that, Ryan. Professor Carpenter?
Sure, and thanks again so much. I would love for USPTO to understand that it is equally bound by the requirements of federal Indian law, as is any other agency, the Department of Commerce, as is any other department, And as the trustee to Indian tribes that has enforceable obligations, as well as a lot of federal policy relevant to its negotiations and positions. WIPO, I think, is a bare minimum, sticking up for tribal self-determination, tribes' cultural rights, as articulated here in the preamble's reference to the declaration and the disclosure requirements. I mean, I telegraphed this earlier. I think those are the barest minimums that we should, possibly expect out of USPTO at WIPO. But also, several have made this point. It's not. It is PTO representing the U.S., but it is the United States, and it is, the State Department, Interior, Commerce, all share these obligations to tribes. And they share them just as much when they go out in the international arena as they do here at home. And all of this protection will require international domestic and tribal work. But I'm pleased that, and I hope that tribes will feel confident to go to the consultations or submit comments. I mean, everybody on this meeting has something relevant. People have decades, lifetimes, generations of experience to share with respect to their genetic resources, their plant knowledge, and so on. And so I really, really hope that they will, and whether it's, expressing tribal customs, laws, and traditions, or telling a story, or citing a treaty, or whatever they feel is relevant, I really hope that tribal governments and lawyers will articulate that, and that PTO will know that we're all super engaged, and will sort of meet us halfway in that regard. So thanks very much.
Yeah, wonderful. Thank you, Professor Carpenter. Sue, would you like to chime in on this?
Sure, just to add to what others have said, I'm hopeful that this consultation effort can be the start of a new phase where USPTO and other US government agencies and departments that are involved in these negotiations or provide input to USPTO related to the negotiations, that we're engaging with them on a continuing basis. As we discussed earlier this morning, that there's continual interaction before, during, and after the negotiation sessions, that it's well in advance so that there's time for our input to be taken into account, and aiming toward respect for free, prior, and informed consent when it comes to the positions the U.S. is taking in the negotiations.
Wow, thank you for that. And I know we have a number of our panelists from the morning as well on. Would any of you want to chime in? I know we have a few folks that are still there. If any of you would like to jump in, you're more than welcome to. I know Preston also has been commenting quite a bit in the Q&A. If Preston would like to jump in there and share a little bit about what outcomes he's been looking for since he's been involved in this for so long, would love to hear from you too. Anyone else want to add their thoughts?
I'm happy to come in, but I want others to come in for me if they're willing.
Sure. Aaron, do you want to give your thoughts?
I really just want to echo what Professor Carpenter said and what Sue and Ryan said, and even Peter. And for the Tulalip tribes, I think what we also really want the USPTO to understand is that every tribe is unique. And there's not. There should be a level of engagement with every tribe. I know there is some talks about capacity earlier today about there's only one tribal liaison for this entire process, and this needs to be a little bit of a wake-up call that there needs to be more capacity and more engagement with tribes at a larger scale. So I think that's a really good ask to put in, and hopefully that's an outcome we can see in the years moving forward, as just that increased capacity within the USPTO and Department of Commerce with tribes.
Thank you, Aaron.
Well, I have a lot of probably maybe some of mine are I tend to be more interpreted as maybe an enforcer or something. I actually am all for the tribes bring up everything they need to bring up. And when I talk about some of the barriers and challenges and limitations, it's just the reality of negotiations as I've experienced it. And again, we can change some things, but we're again on the genetic resources, we're getting towards end game. Now, the hopeful news, I think, is that the WIPO decision on GRs is going to be a framework decision. I wouldn't view it as the end game, as I mean, the final decisions, because we've, for example, it was the Indigenous Caucus that proposed and introduced, and it's still on the table, to have a review clause that says every 4 years that we have a review of the convention. Now, in terms of conventions, it turns out intellectual property rights conventions tend to be a lot more easy to revise because IP is such a dynamic and changing situation and involves changes in technologies oftentimes. And technologies are moving at a very rapid clip. We haven't even talked about AI, for example. So there is going to be some future scope in that. But again, on the GRs, the bad news is I think it is true. We just can't get a whole volume of things. And in the chat, if you'll read them, I've given some suggestions on, we need to strategize. There is still some scope for bigger issues, but they have to be very limited, and we have to decide, okay, let's target this as an issue, because it's going to take a lot of work and you have to put your shoulders to it. It also means talking to other nations. So any of you who have connections, especially with the offices or the negotiators at WIPO, please forward your comments to them and start talking with them, because getting state support is really going to be critical on moving forward on any of our big issues. We haven't talked about the CBD much. And again, I'm hoping people think about digital sequence information. It's also moving at an incredibly rapid clip. We're going to have a decision out of the Convention on Biological Diversity next December on it. We already have processes started. We're going to have informal meetings of a technical working group that start next week. And they will occur every single month, and there will need to be discussions every month. So again, just to let you know, I'm willing to participate and help out. I'm currently leading the CBD negotiations on DSI. So that's another one that we need to have a lot more discussion on. But I think we're in pretty good shape. We have some good shape on TK and TCEs. They're still a ways away, I think. But that's all I have to say. I mean, again, I've said what I think some big ticket items, of course, are do we get something more substantive out of disclosure? As Peter said, that's a finely tuned balance, but we might be able to get something a little more substantive. Public domain, of course, is not there. We need to be vigilant. We need to make sure that it doesn't come back in and isn't smuggled in a definition. So those to me. And then again, make sure that Indigenous peoples in all of the open questions, and this is what we've tried to do, make sure that we're compliant with the declaration that says Indigenous peoples have to be consulted on all of these issues. So we are trying to pack in where there's open-endedness, of course, which there's going to be. It's an international convention, has to be generic. Make sure that we're involved in all those discussions, and that would require domestic consultation. And also get hold of the White House. We got hold of Kim Teehee, and we actually got some good responses when we did the first round of discussions on the adoption of UNDRIP under Obama. They were very helpful, and the State Department is aware of this issue. I've talked to them recently, and might be something to reapproach them on State Department's oversight role. Thank you.
Thank you, Preston. Thank you for reminding us of all of those things and wonderful outcomes. I do hope we get all of those. I I wanted to also invite June Lorenzo to join us, who's been involved with WIPO for many, many years. June, would you like to share some of your thoughts on this? You know, what outcomes are you looking for? What are your aspirations here?
Sure. Can you hear me?
Uh-huh. Yep.
Okay, well, I apologize. I've remained silent all day because I've actually had the flu and I haven't been able to speak for very long without coughing. So I'm going to try really hard not to cough. I'm reminded of a couple of years ago when we met with the Canadian delegates, and they said that their instructions were really to implement the UN Declaration on the Rights of Indigenous Peoples. That those formed their instructions for their statements and the positions they took. I would, of course, love to hear the United States say that, but they haven't. But that was so clear that that informs the positions they take. And the United States, I would love for them to hear from Native nations and intertribal organizations, and to get a large picture, just a sense and a responsibility, as Professor Carpenter said earlier, that there is this relationship that they have with Native nations in the United States. And for that to carry them, I mean, I've seen it's so frustrating when there are debates about customary law. There are debates about whether, you know, even tribal courts exist, and they remain silent. They remain absolutely silent when they have numerous examples of what sovereignty means on the ground, of what tribal law means on the ground, of what customary law can mean, and they remain silent. And so for them to have an overarching sense that they have this relationship that they need to honor, and as others have said before, they need to carry that into international fora, having that then informs so that we can take that overall responsibility and knowledge into the kinds of analysis, text-based negotiations, and the analysis that everyone has so wonderfully articulated today. I would love to have them hear from Native nations and understand that deeply, because I don't think they do. I mean, we have these ridiculous meetings with them as the US delegation almost every IGC session, and we go through the same thing, and things we ask them to say or support, we don't get that support. But United States has so many examples that they could use, and they choose to remain silent. So I would love for that to come out of a consultation, and a series of consultations, as it were, with nations and intertribal organizations in the US.
Thank you, June, for that. And absolutely, I'm hoping that's what happens as a result of all of this too. So we have certainly our work cut out for us, right? Lots of comments to write, lots of things to say on the consultations next week. And we've been certainly armed with lots of great information and arguments and thoughts by all of our panelists. And so I want to thank each of you for being here today, sharing your thoughts, and providing guidance. I think it's going to be incredibly valuable, not just for this round of consultations, but for many years to come. So we're going to go ahead and make this this set of panels available via recording to be distributed. And hopefully we can all circulate this to those that weren't able to make it today. But I just want to, again, thank all of you for all of your support. Thank you to our sponsoring organizations for being there for us and organizing this in kind of record time, getting this all put together. So thank you very much. Have a great rest of the week, and we look forward to the consultations and comments coming.
Thank you, Trevor. You've been amazing and spearheading all of this. So with all of our thanks.
Wonderful.